Supplementary list for pronouncement of judgment. Item number 30, W. Read appeal 110 of 18.
In wake of the discussion made here and above, we find no impediment in the order passed by the single judge, and hence the writ appeal fails and the same is dismissed as being void of merit.
Item number 32 and 33.
The impugned judgment and order dated so and so is hereby reversed and set aside. As a consequence, both the appeals are allowed.
Much obliged.
For judgment, item 34.
In view of the board discussion, we hereby direct that the Khadi board to refer the matter of promotion of the respondent board so and so to the handloom, textile and sericulture department. The controversy shall be examined by the secretary of the department in consultation with the secretary of the Department of Personnel, Government of Assam. Till such process is undertaken, the respondent writ petitioner shall continue to hold the post of superintendent. However, she shall not be entitled to claim any lien on the post on based on the promotion order dated so and so, and the order passed by the single judge in so and so. But promotion to the post of superintendent will be dependent on the decision taken by the secretary so and so. However, in case of any adverse order, the respondent shall be entitled to challenge the same as law.
Much
The writ appeal is disposed of with the above observations and modification in the order dated shown. Last में line add कर दीजिए. In case of any adverse order being passed, comma, the respondent petitioner shall be entitled to challenge the same as per law. Just above parallel. Start. Item number 5 to 20. Item number 40 to 33.
Yeah, please, your lordship.
Yes.
Lordship, I would like to mention item 17 of the daily list. Lordship. In
What
this matter,
happened?
we need to file our affidavit in reply. We need some more time.
Counsel for the petitioner pays for and is granted 6 weeks time to file affidavit in reply. List after 6 weeks.
Deeply
As per-
obliged.
I pretty mention item number 18.
Mhm.
I'm awaiting instructions in this matter, my lord. They had brought an affidavit in reply with certain documents of the government. I have sent them, they have to come back.
Mr.
2 weeks time.
Counsel Mr. Muzumdar prays for appearing for the education department,
My lord,
appearing for the education department, prays for and is granted 2 weeks time to complete his instructions.
I'm obliged.
You would be filing some affidavit also,
My lord,
not required.
no, they had brought on record a committee's report. If the report is not agreed to, that I have to bring on record. If it is agreed to, then my lord.
And if required, come on, file an affidavit, additional affidavit on behalf of the department.
May
I'm
it please
obliged.
your lordship. Lordship, I beg to mention item number 14.
Mhm.
Lordship, in this matter, Mr. PJ Saikia is appearing, your lordship. I pray that the matter may be listed before any other bench, your lordship.
Okay, let's be for another bench. Okay.
Deeply obliged.
May I please, your lordship?
Mhm.
Lordship, with the consent of the other party, lordship, I beg to mention item number 28, lordship, for adjournment.
And counsel for the petitioner has circulated an adjournment slip. The other side has no objection. List after 6 weeks.
Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention listing a writ petition, lordship, on Thursday, lordship.
Is it a fresh matter?
No, lordship, at hearing matter, lordship. It was calm, lordship, but not listed, lordship.
Hearing matters, take a date after 11th, not on Thursday. Thursday will not be possible. 12th को दे दीजिएगा.
Obliged, lordship.
Lordship, may it please, your lordship, I have a similar prayer. This matter was supposed to be listed after 3 weeks.
Hmm.
So may I pray?
Hearing matter,
Yes, can it be listed on 7th? If it's not,
7th, all right,
I'm
7th.
deeply obliged. Your Lordship.
Very well.
Daily list for orders, item 4.
We have filed an affidavit
Hmm.
regarding the justice service, my lord.
2017
My lord,
delay condonation going for last 6 years.
my lord. We have completed the service, my lord.
You have completed
Yes,
service. You filed an affidavit.
my lord, yes.
When?
My lord, this affidavit was filed on Thursday last month.
There's no affidavit on record. Mr. Mazumdar said that he has filed an affidavit in proof of dusty service.
My lord.
The Lavazima court to check and report list on and list the matter on 13th September.
Obliged.
Item number 5.
May I please, your lordship? Lordship, in this matter, due to I flew, the petitioner couldn't come to sign in the affidavit in reply, which we were supposed to file. So kindly grant us 2 weeks time to file our affidavit in reply.
And counsel for the petitioner, please submit that the petitioner has not been able to swear the affidavit because of illness. She prays for and is granted 3 weeks time so as to file an affidavit on behalf of the petitioner. List after 3 weeks.
Obliged.
Item number 6 to 9.
Here you Have they filed the plan, vending plan? No, you have not. Vending zones, yes.
Yes.
Mr. Nayak was supposed to be here.
My lord, Mr. Pinayak is stuck on traffic, my lord,
Pass.
pass out through the-
Item number 10,
May please. My lord, as per the last order, my lord, the implemented respondent number 8, my lord.
Respondent number 8, who is coming, who is
Hill area
appearing?
Department, my lord.
Hmm?
Hill area department.
Mr. Nath had appeared. Where is Mr. Nath? Password. Yes, Mr. Chaudhary. Hmm? Where is my password? Let Mr. Nath come.
item number 11,
Wait, your lordship.
Hmm. Yes, you have filed an affidavit.
Lordship, we have already filed affidavit.
Who is there? Mr. Gogoi, yes. They have tried to demonstrate that you have not complied.
We have complied, my lord.
Read their affidavit.
Affidavit has been, we have received affidavit. My lord, another set of orders has been passed, whereby, my lord, the junior cadre has also been given, my lord, considered, my lord.
Take your time. Don't rush the things.
Gradation list of the junior cadre also has been prepared, my lord.
Some additional
Yes.
orders have been passed, fresh order.
No, my lord, this was the parent order, basically. Basically, my lord, this is the parent order.
Hmm.
And from the, only from the junior, the seniority flows out, my lord.
Mhm.
And as his case, my lord, they have a case that they are not considered. My lord, they were considered and not found eligible, my lord.
So that whether that order has been brought on record.
No, this has been to be brought on record. my lord.
So then bring that order on record.
My lord.
Mr. D. Gogoi submits that a fresh order has been, an order has already been passed. After considering whereby, comma, after considering the case of the petitioner for promotion, comma, he has not been found eligible. The same be brought on record through an affidavit
Acknowledgement.
list after 3 weeks.
Acknowledgement.
item number 12,
Abandoning service. Yes.
My lord, the writ petition was filed, my lord, challenging the order of removal of from services
Hmm.
on the ground basis.
Not removal, abandonment of service. There is no dispute about that. You were transferred, you did not go and join. What the authorities were supposed to do.
My lord, we have given the reply to those letters, my lord. And they're saying that it is, if I may take your lordship to that letter, my lord.
Anyhow, now he has crossed the age of superannuation.
Yes, yes.
So otherwise also the principle is well settled. No pay for no work. So what is going to happen now?
Now,
What he is going to get?
My lords, what my lords will kindly see, my lord, whether the principles of natural justice.
Provident fund and all those things have already been provided to him.
Yeah.
What is the principle of natural justice in a transfer order? It was a simple transfer order, one plant to another. Do you dispute that? Then whether an employee is supposed to be heard before passing a transfer order?
No, that
Then-
is not required.
Then why principle of natural justice comes into picture?
My lord, if I may take your lordship to the order of removal, my lord.
All right,
Page 43, my lord, may I read only two, 3 lines, my lord.
Yes.
And whereas in the above referred communication, he was also intimated that he is unauthorizedly absenting and
Yes.
abstaining from joining the duty at Tandoor, and that in case he does not join duty finally also, he shall be presumed that he is no longer interested in continuing.
Yes. All right.
Now, my lord, with regard to that, my lord, may I place a office memorandum, my lord? Of.
Gentlemen, satisfy us on your conduct. Why didn't you join at the transfer place? Forget the memorandums.
My lord.
Why didn't you join? Tell us. Thereafter you filed a writ petition. Okay. Was there any stay operating in your favor?
No, no.
No. You could have requested the writ court. Sir, please stay the termination order. We are ready to join. Was it any offer? Was such an offer made on your behalf?
That was my lord.
Never made.
That is
So-
not there. I mean, if I may allow to place.
All right, let us see the office memorandum.
Really?
What is the memorandum? You must have argued it before single judge.
But that was not brought to the records, my lord.
Also, there's a new ground. Whether in appeal you have taken this ground,
Yes.
That- let's see. Regularization, yes.
Now, my lord, point number 3, this is with
Hmm.
regard to procedure dealing with unauthorized absence.
Hmm.
Point number 3, my lord, if I may read it. It is once again stressed that a government servant who remained absent without any authority should be proceeded against immediately.
Hmm.
All ministries, departments are requested to ensure that in all cases of unauthorized absence of a government servant, he should be informed of the consequences of such absence and be directed to rejoin the duty immediately within a specific date, say within 3 days,
Hmm.
failing which he would be liable for disciplinary action under CCS rules. Now, my lord, if there is an unauthorized absence, the
Hmm.
consequence is facing the disciplinary proceeding, not taking a presumption that he is not interested to join the duties.
Hmm.
The basic leg of my argument is that, my lord, that if a person is absenting unauthorizedly, the consequence is he would face the disciplinary proceeding.
Hmm.
This does not give the employer to take a presumption that he is not interested in continuing his duties.
Hmm. How long did you stay without joining? Tell us the
My lord,
exact
the
period.
initial transfer order was in 2008.
8 and 2010, other than just writing it out in the courts, the termination order came to be passed after 3 years.
3 years, my lord.
Where's the termination order? Let us see.
Page 43, my lord.
Let's read it.
Yes, your lordship.
Hmm.
May I read it, my lord?
Hmm.
Whereas R.K. Mahanta, electrician, CCI Bokazan was transferred.
And you yourself informed that you were not ready to join. What is the employer supposed to do? Send a chartered plane for you?
No,
Why inquiry was at all required?
If I may, like, take a lordship to the.
Read the order. We have read it, sir.
Yes.
Hmm.
She was transferred from Bokazan factory to Tandoor unit factory by order dated 28/8/2008.
Hmm.
And whereas he was relieved from Bokazan cement factory by order dated so and so dated 30/8/2008. Further, by these letters reference number so and so, R.K. Mahanta was directed to report the duties at Tandoor unit as he was absenting from duties and from joining and was given adequate opportunity to report. And whereas in the above referred communication, he was also intimated that he is unauthorizedly absenting from joining duty at Tandoor unit, and that in case he does not join duty finally on so and so, he shall be presumed that he is no longer interested in continuing in the service of the corporation, and that his name will be removed from the rolls, treating that he has abandoned his service at his own.
Then next,
And where
4/12/2010, letter dated 4/12. Where is that letter?
my lord, page 41.
Page 41. Read that, sir.
With response, I do thankfully acknowledge the receipt of my above cited letter under reference, sir, so and so. Number 1, my lord. If it would have been practical on my part to join at Tandoor Cement Factory, I would have joined and then there while I was transferred, as it was not practically possible while I received and transfer order, and still I am not in this position owing to the reasons, showing the reasons I have already narrated at my previous letters, and the best known to your good self is not deemed necessary to report again. If it would have been practicable for me, I would have not awaited until now. So spot my service where I earning my bread and butter. In the teeth of the non-consideration of my prayers permit me to remain at the Bokazan cement factory by my employer, as we both husband and wife working here pulling on with our school going children, finding no way out to seek justice, I apply to the judiciary honorable machinery of justice of our country. And my prayer is under judicial process, and during the course of judicial process, and I am handicapped to take any decision unilaterally from my side with the utter disregard to the judiciary of the government of India. In the meantime, I would like to inform you that the next date of hearing of the above mentioned transfer case is on 20th January 2011, which had been fixed by the Honorable Guwahati High Court. In view of the above, as amended by the judicial process, I shall have to wait till the final discussion of the judiciary.
He was taking full advantage of the fact that he had obtained the law degree in the intervening period by raising all these grounds.
Now, Madam,
What is the employer supposed to do? Tell us. The employee says, I am not going to join. What is the response which the employer is supposed to do? What kind of inquiry is contemplated in that situation? Not only abandoning, absolutely obstinate response that I am not going to come. You just keep on waiting for the court decisions. Well, the court decisions are here. What to do? You filed a writ petition in 2008, challenging your transfer order. That was dismissed. Thereafter, you did not join. Why are you not in contempt? Tell us. Did you file any appeal against that?
a review was filed, my lord.
Any appeal thereafter?
Appeal was filed, there was a condemnation of delay, my lord. And during the pendency of the condemnation of delay, my lord, the transfer order was
Transfer.
issued.
Not the transfer, the termination.
Removal order was issued.
So then what is to be done? He was not ready to join, gentlemen. All court proceedings, they waited for that. Despite that, you say, though, absolutely forget it. I am having the degree of law. You keep on fighting me in the courts. That's all.
Now, my lord, will kindly see, my lord,
Yes.
whether the order of removal, my lord, was in consonance with the law of principle of justice.
Yes, Mr. Roy, what do you say about this? Why didn't you hold an inquiry?
My lord,
Was it not required?
in some cases, inquiry is not necessary.
Dispense with whether there was an order of dispensing. That is a case wherein inquiry cannot be
This is-
conducted.
My lord will see the letter dated page 38, my lord,
38.
38. Prior to that also, my lord, he replied this.
We understand. We understand.
He
But
said
for a
that-
name's sake, you could have conducted an inquiry, said,
Yes, correct. But
Then-
he say that, my lord, that he will not join, my lord.
all right.
His lordship
So
will say
then
that.
you
Then
could
inquiry
have
is-
just a formal inquiry that he is not ready to join, he is not willing to serve. That is why terminated. But whether you could have done it in this manner,
That means, my
show
lord,
us some law.
yes. my lord.
फाइल को नहीं मिला ना फाइल को नहीं मिला है ना फाइल को नहीं मिला है ना
Yes. Lawyer from Arunachal Pradesh. Which is the judgment you're citing?
My lordship may say, number one judgment, no notice is required at that. Para, my lord.
Single bench judgments of high court, sir.
Then last judgment, lordship may see 1919 and 7 SCC. Last will.
885.
Page 89. Para 7, my lord. Page 89, para 7. I'm reading the last para, my lord. Fifth line. This apart, admittedly,
So cause notice. So cause notice.
show cause notice is given to him.
Given.
That is the, his response is that to that.
That is the direction to join. It's not a show cause notice.
Then lordship may see. Para 8, my lord.
Also, the court took upon itself to find out whether there was any defense on merit. That's right. That is one way of taking things. What do you say? Read para 8. This cannot be a case wherein the where allegations and charges cannot be in a case where allegation and charges are admitted and no possible defense is placed before the authority concerned. What is your possible defense against non-joining? Tell us.
I'm sorry, Your Lordship.
What is your possible defense against non-joining of duty?
My lord, here, my lord, there is the both husband and wife, my lord, they were working.
Forget about it, sir. There is a transfer order which has stood the test of litigation by after rejection of your writ petition.
That order was SL before the honorable court, my lord. The
So
writ petition was dismissed.
whatever you could have said, still said, no, all right, examine the validity of my transfer order also. You tell us now what is wrong in the transfer order. Why couldn't it not have been passed?
Yes, well, the both husband and wife, my lord, they were working in.
So there may be a policy
They
to
are,
keep these spouses together, but they are all right. They are deviating from policy. That doesn't make the order illegal. There are many officers in this
Yes.
Assam State Judiciary, Judicial Services, wherein we have a policy, but many a times we are compelled to post them at different
yes,
stations.
and father, my lord, the children of the petition.
Yes,
My lord,
all right.
they were in.
So that is why the wife was not transferred. She could have taken care of the children. Probably because of this man's performance and behavior that they were compelled to do it. They may not have brought it on record. Otherwise, no employer takes such a harsh action. Thank you. Anything else to say?
My lord, the proviso to 311, my lord,
Hmm.
they said if disciplinary action was not initiated, that can also be done, but that has to be given a reason by writing. That part is
This
not.
is not a case of simple disciplinary proceedings, gentlemen. This is a case of an employee who refuses to join. Even in this court, we asked you a pertinent question. Did you ever make any offer that yes, I am ready to join on the transfer post? Read from your pleadings.
No, that was not there.
Not there, then chapter closed, sir. Dismissed.
Deeply obliged, Your Lord.
Item number 13.
May it please your lordship, my lord. My lord, before I start, I must point out one thing, my lord. Out of the same impugned judgment, my lord, lordship has another writ appeal was filed that lordship has admitted for hearing.
We'll admit this one also.
Yes, my lord, I'm
Admit issue notice, connect with so and so. Net slat, PhD. What is the IE about?
I was, we were, my lord, paying before your lordship for the interim order. I'll not press, my lord.
IA for interim relief not pressed.
Lordship may had it along with the petition, my lord.
All right.
Kept in pen.
Then counsel for the petitioner does not press the prayer for interim relief at this stage.
At this,
That's all. Will not dispose it of.
my lord, at this stage.
Both the matters may be taxed, my lord.
Both the matters may be taken.
Service upon the respondents be effected by providing copy of the writ petition, writ appeal to the standing council concerned. Are there any private parties?
No, my lord.
No.
Principle is there, but I will serve, we can serve Dusty, my lord.
The service upon respondent number so and so be effected by Dusty mode. Steps to be taken in 3 days.
My lord, I'm obliged. Dusty will be routed through the registry.
Dusty will not be routed through registry. By our usual process kar dena.
All right, we'll take this steps.
Item number 15.
Yes.
My lord, at the outset, my lord, may I make one submission, my lord?
Yes, please.
My lord, since this writ petition challenges the administrative decision of the Honorable Chief Justice, my lord, in the principle of no one is a judge of his own cause. My lord, may I pray that your lordship may recuse and
Mr.
then
Patel, you have
let it be
argued the
heard.
matter for some time. You took the risk of getting our opinion and then you want to raise this argument. That is deprecable, we will say. Don't take the court for granted. The same
No, my lord.
situation was presented before Honorable Supreme Court. And if you want to really go ahead in that manner, we will take care of that also.
Yes.
All right. We are
No, my
not,
lord,
all right.
yes, my lord.
We'll take note of that argument. And we'll also mention it in the order that you argued the other day without any objection, without any semblance of a doubt. And now you are trying to just indulge in bench halting and trying to get the matter shifted to another court, which we absolutely deprecate. You want us to record that in the order?
No, my lord, and on the first day also, we have submitted that this challenge may not be construed as a this thing. But then
No, Mr.
we
Patel,
are not-
yes. No, we are not construing the challenge to be anything, but these words which, this ground which you have raised today, that is unacceptable, absolutely.
my lord.
Yes,
My lord, my continuation to our submission is that, my lord, apart from the notification, there was a this thing order of the High Court that the 26/10/2006, my lord.
where is that order? Page number?
Well, that copy has been made available, my lord, to your receipt that day also.
That's court master. They have sent some copy.
Order number 41, that the 26/10/2005.
Yes, last date they were referring to it. Not available in my file, some of the other.
It was on record last time.
It's there in one file, Mr. Raya.
I'll give a copy, man.
Yes, please do.
It copy.
Yes, read it, please.
My lord, in supersession of all the earlier orders issued in this behalf, it is hereby ordered that all the cases pertaining to the permanent benches of Guwahati High Court, namely Kohima, Nagaland, Shillong, Meghalaya, Imphal, Manipur, Agartala, Tripura, Aizawl, Mizoram, and Itanagar, Arunachal Pradesh, whether filed at earlier point of time or to be filed in the future at the principal seat for absence of appropriate bench at the outlying benches, shall stand transferred to the respective benches of the High Court immediately after completion of motion and or admission, my lord.
Yes,
My
all
lord,
right.
this is decision by the High Court. My lord, this has not been repealed or
All right.
superseded. Now, my
It's
lord,
it was a one-time
uh,
action, Mr. Patil.
yes,
It was not an absolute order that this will continue to remain alive in future also. This was a one-time measure.
but since this issue has a serious ramification over the competence and jurisdiction of Itanagar Permanent Bench,
Yes.
your lordship may be pleased to see that just question of discretion may not be exercised, cannot be exercised to confer a jurisdiction or to transfer a jurisdiction where the cause of action hasn't arisen. Our submission is that we are we are not saying that we are not under the principal bench of the Guwahati High Court, but my lord, that is for the superintendent.
This is not a
As far as
principal
the
bench.
functioning of the
Mr.
High Court is
Patel,
concerned,
correct
lord.
yourself. This is not the principal bench. This is the principal seat.
Principal seat, my lord.
Yes.
So, my lord, our apprehension is that since the Itanagar Permanent Bench, for the purpose of Article 214, read with 231, it is a separate High Court for the state of Arunachal Pradesh. So, for the cause of action that has arisen within the state of Arunachal Pradesh, the Itanagar Permanent Bench shall have the jurisdiction, and
That
this
you have argued,
jurisdiction
sir.
cannot
That
be
you-
transferred by
That you
virtue
have
of
argued, Mr. Patil. You need not repeat. We will address your arguments when we are considering the matter. You need not repeat. You just wanted time to add something. Please add whatever you want to do, what you already argued on the last date.
My lord, another is all this impugn order I have gone through, my lord. it has
Impugned order.
no
Which is the
reasons has
impugned?
been assigned.
Ah.
An administrative decision, at least the basis should be provided. For that, my lord, may I just cite 2016 1 SCC, my lord.
Yes. On SCC page.
Page 2724, my lord.
724.
Paragraph 4, my lord. I'll read paragraph 4.
Yes, please.
There can be no gainsaying that every decision of an administrative or executive nature must be a composite and self-sustaining one, in that it should contain all the reasons which prevailed on the official taking the decision to arrive at his conclusion. It is beyond cavil that any authority cannot be permitted to travel beyond the extent adopted and expressed by it in the impugned action. If precedent is required for this proposition, it can be found in the celebrated decision titled Mohindra Singh Gill versus Election Commission of India,
Yes.
of which the following paragraph deserve extraction. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order had in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observations of Bose J. in Gorbandas, Haji Sansas. Public orders publicly made in exercise of an statutory authority cannot be construed in the light of explanation subsequently given by the officer making the
Mr.
order.
Patin, first of
what
all,
he
the
meant.
Chief Justice, Mr. Patin, his judgment doesn't apply. The Chief Justice of the High Court is not a statutory authority. So you can't equate the statutory authority with the jurisdiction of the Chief Justice.
No, my lord, if we
Yes.
take the first decision of his lordship, then the Chief Justice, my lord,
Yes,
may I take
please.
your lordship to page 35 of the writ petition, my lord.
Yes, please.
My lord, this was on the basis of an application received from the one Mr. Apuras Gogoi on behalf of the NSPC, my lord.
Yes.
Honorable the Chief Justice, reference WPC number 5402/2020, subject transferring of the above referred matter pending in the principal seat to Itanagar Permanent Bench of the Honorable Guwahati High Court. PUC is a letter received from Advocate Apuras Gogoi. He is a counsel for the NSPC. By the PUC, learned advocate has prayed for transferring the aforesaid writ petition to the Itanagar Permanent Bench, stating that some other cases involving the same issue as in those above referred matters are pending in Itanagar Permanent Bench of the Guwahati High Court. Therefore, in view of the above, if it pleases your lordship, A, registry may be allowed to transfer the above referred matters pending in the principal seat to the Itanagar Permanent Bench of the Honorable Guwahati High Court, or as your lordship may deem fit and proper, laid before your lordship for consideration and necessary orders, joint registers, such and such. Well, the decision of the Honorable Chief Justice then is not required. Since something just all the records may be called for, that is, my respectful submission is that this matter ought to have been considered from the light of the cause title. And there is in this 5402, there is an observation by the registry of the principal seat that neither the state of Assam is a party, nor the officials, any of the officials of the state of Assam is a party. So it totally pertains to the state of Arunachal Pradesh. So with that notings, the file was the case was sent up. Now that is how this thing has started, my lord. So my lord, our respectful submission is that since I'm just for the purpose of repetition, my lord, since Itanagar Permanent Bench, no doubt under 231 of the Article 231 of the this thing is under the Common High Court, but for the purpose of state, the Itanagor Permanent Bench is a separate high court for the state of Arunachal Pradesh. So the course of action that has arisen, this has in Arunachal Pradesh, the matter has to be heard by the Itanagor Permanent Bench. This cannot be subsumed by exercising the discretionary power under proviso to paragraph 2 of the notifications. My respectful submissions, that may
Yes,
not be taken otherwise.
Yes, we understand. Yes.
Yes, my lord.
Okay.
Now,
Yes.
and then, as far as the roster is concerned, my lord, the Chief Justice is a common master of roster for the Assam, Mizoram, Arunachal Pradesh, and Nagaland, my lord. But my lord, when your lordship is exercising the role as a master of roster for the Itanagor Permanent Bench, your lordship is acting as the master of role for the Itanagor Permanent Bench. And and likewise for the Assam, Nagaland, and Mizoram, your lordship is performing separate authority, my lord. Like, my lord, for example, if I take an example, my lord, the governor of Assam or governor of Nagaland may be given the other responsibility of governor of Meghalaya or Assam. My lord,
They do
if
not
the
have
governor of
jurisdiction, Mr. Patil, but they, as such, under the constitution, they do not have any jurisdiction to pass any orders pertaining to the matters covered by the other states. So whereas the Chief Justice of Guwahati High Court is given that jurisdiction to deal with the matters
is there.
pertaining to the benches. Right? So that analogy doesn't apply. Prime facie.
there, my lord, we do not have any doubt on the discretionary power of the Honorable Chief Justice, my lord. But only thing is that my lord, the exercise of that discretionary power, my lord, it cannot subsume the very purpose of the paragraph 2, my lord. I respectful submission, my lord. And my lord, what I'm submitting is when the Itanagar Permanent Bench is functioning at Itanagar in Arunachal Pradesh, my lord, the principal seat, the High Court sitting in Guwahati is functioning as the High Court of State of Assam. Apart from the some cases under different circumstances.
Is there any
which has been-
separate high court for the state of Assam? Is there a separate high court?
Lord, the implication is that when all these benches are functioning, it means state of Assam has its
Then,
own
Mr.
high court.
Patil, just let us know.
My lord.
Then what would happen when some judge which is stationed at the principal seat, he comes, he's sent for a week or two to hold court at Itanagar, whether he will not be having jurisdiction to exercise that power. Because he's stationed, he's a stationed judge at
There is no
Assam.
doubt about it, my lord.
He is stationed judge at Assam. If your argument is to be accepted, perhaps by implication, this judge stationed at Guwahati would be having the same status as a judge who is holding court in the Meghalaya High Court, because you are trying to distinguish the two high courts. As if Itanagar, Arunachal is a separate high court. Is it is it the argument which is coming from you?
But although
Perhaps we
it
would
is
have to rethink.
it comes
would
under
have-
a common high court, high court, my lord.
We would
Although
have to
it comes under
rethink.
a common high
We
court.
would have to rethink before sending honorable judges from Guwahati High Court principal seat
My lord,
to Itanagar bench for this.
that is not our intent and intent of
That's
our
not the
submissions, my
argument you
lord.
are making, Mr. Patil, by saying that Assam High Court is a separate High Court, distinct entity from the Arunachal High Court. You are very well projecting that very argument, sir.
My lord, this is prerogative of the Chief Justice of Guwahati High Court to
Yes.
allocate which we need judges.
You just
Has
now
to
said
be-
that Guwahati High Court Chief Justice only has the jurisdiction to decide roster within the state of Arunachal Pradesh. So if that is
No, my
so, how can the
No, my lord,
Guwahati High
for
Court
the
Chief Justice
entire
assign
four
a
states.
judge to hold
Entire
court?
four states.
Yes.
For the entire four
Four
states, my lord.
yes. 4 states, we understand. In that event,
And-
how is the Chief Justice or having jurisdiction to place a judge in any of the benches. Because the judges who are stationed in Guwahati, they would be required to hold the roster here only. If that is the argument coming forth.
That power is exercised on the administrative side.
So this
Not-
calling of the
not,
files,
not
Mr.
on
Patil,
the judicial
Mr.
side.
Patil, if honorable judge can be
Matlab,
stationed,
Your Lordship,
Mr. Patil, just hold on now. If honorable judges from the principal seat can be stationed in the benches, where is the difficulty in calling a one file or two to be decided by the principal seat? If the chief justice has the jurisdiction to assign a number of judges to hold court in Itanagar, you mean to say that the chief justice would be powerless to even transfer one file from Itanagar to Guwahati for being decided? Anyhow, you conclude your argument, sir. Thank you. Anything more to say?
In the may I just cite yesterday's this Rajasthan case,
Yes.
Paragraph 17, 2001, 2
You read
SCC,
it, Mr. Patil, we told you that was a matter wherein jurisdiction was being changed. The chief justice was deciding jurisdiction. We are not at all interfering in jurisdiction. Had that been so, perhaps we would have said, all right, all cases of Teju Alu will be listed before Guwahati High Court. We are not saying so. That is not the intent of the chief justice's order. A particular matter
But,
in a
in
given
fact,
facts and
it is-
circumstances is transferred to Guwahati. There is nothing, no wrong in that. Nothing wrong. Honorable Supreme Court transfers matters from Sikkim to Guwahati High Court. From Meghalaya, we are hearing matters. Does it mean that we don't have jurisdiction to decide that case? Then we are not changing
exercising the transfer power under section 24 and section 25 of the CPC it's totally a different aspect, my lord. My respectful submission, my lord. This issue is not transfer of cases simpliciter under order 24 and 25 of the CPC, my lord. Because here it is question of interpretation of the paragraph 2 read with the proviso, like whether the proviso can subsume or negate the intent and purpose of paragraph 2. And my lord, this has a very serious ramifications.
Yeah,
Because,
Mr. Patil, now we are putting you a simple question. A situation arises that there are only two judges stationed in Itanagar, right? For a period of 6 months. They are dealing with either one single bench matter or the other. Where do the appeals go?
Exactly, my lord. That is what I wanted to place it. Supposing today the two judges are sitting here. Both of them are holding the division bench also. But one of the if it is the decision is against one of the decision of the sitting judge, then we don't have any forum. In that situations, we will
Then why?
definitely come to
If
Guwahati.
the,
We'll approach
Mr.
you,
Patil, if your
Your
argument
Lordship.
is to be accepted, it is an absolute proposition. It can't be dependent on the
That is my
number of
submission,
judges
my lord.
present there. No.
There are definitely certain
Your
situations
argument, Mr. Patil, so it is all as per convenience, right? It's a matter of convenience when the matters are to be heard here, when the matters are to be heard at Itanagar. That is what your proposition is.
My lord, it is not a question of convenience, my lord.
Yes.
My lord, it is the circumstances, the fairness and circumstances.
So if it is dependent on particular circumstances, then have faith in the decision of the Honorable Chief Justice who has transferred the case here. All right. If this is an absolute proposition coming forth, there will be a situation that you will be rendered remediless. And all right, you will have to file SLPs before Supreme Court, get the matters transferred to any other high court. That is the only situation which we perceive that might be faced by people at Arunachal Pradesh. Thank you.
My lord,
Anyhow, we'll consider all your arguments. Yes, Ms. Tara. Your submission was that please keep this petition pending. We are not doing that.
Grateful, Milord. I have made my substantial argument other day.
Yes.
Today, I do not have much to supplement either.
Okay. Very well.
Since the opinion that has fallen from my lord is very loud and clear that Lordship is not going to keep the matter pending and resolve this issue through mediation. That is within the domain of my lord, and my lord will appropriately exercise the wisdom so that nothing should go wrong while laying down the law for the interest of the both the benches under the principal seat, my lord.
Yes.
Having said so, my lord,
Yes, please.
prudentially, my lord, prudentially, it would still be proper to have a considered thought on the advantages of the litigants, basically who are from Arunachal Pradesh. There is no point in advancing further argument, my lord, that Honorable Chief Justice is not the master of the roster or either on the course of action and the territorial jurisdiction. Anything, my lord, may law lay down the law that should serve the purpose of justice so that there is complete cohesiveness between the two benches of the Honorable Guwahati High Court. But there is one.
Three. Correct yourself, Mr. Tara. There are three
My-
benches. Three benches.
My lord, only without prejudice to my lord chair, I only make one opinion.
Yes, please. Go ahead. Yes.
But what is being perceived by me is that although Itanagar, Aizawl and Kohima bench are permanent bench within the ambit of the Honorable Guwahati High Court, if I give a thought process to the notification that is at page 349 of the 2022 rules, my lord, with the proviso that provided that the Honorable Chief Justice may exercise the discretion, my lord. Discretion, while exercising the discretion, my lord, it is the question that a German for all the issues to be resolved. What are the intervening or what are the circumvening circumstances that has led to Honorable Chief Justice to take a decision to transfer the matters from Itanagar to principal seat, my lord. Therefore, my lord, it is one aspect of the matter. The other analogy which might not have already rejected, but my view is this, my lord. Honorable Chief Justice is the master of the roster for the principal bench as a Chief Justice, my lord. That is first among the equals. Similarly, my lord, when it comes to the Itanagar, Kohima and Aizawl bench, there, my lord, is also the master of the roster, my lord, bereft of the independent of being a permanent benches within the ambit of the Honorable Guwahati High Court. So therefore, my lord, I would only make a respectful submission submission and beseeching, my lord, to kindly give a thought process so that interests of the litigants are also protected, my lord.
Yes.
Grateful, my lord.
Thank you, Mr. Tara. Thank you.
Thank you so much.
Yes.
My lord, just to take ahead what they have said, my lord, the confusion I still think continues with regard to the cause of action and the jurisdiction and the proviso.
Right.
That, my lord, unfortunately has not been clarified. My lord, while deciding this matter, my lord will not lay down, it is not laying down any law. The law is already settled. My lord is only reiterating it. Now, my lord, taking the arguments of my friends, my lord, then what they are trying to project now is, my lord is the High Court, Honorable Chief Justice of Guwahati High Court, separate identity of Honorable Chief Justice of Arunachal Pradesh bench, Aizawl bench, and it's not that, my lord. The notification itself, from which it comes, my lord, says that the jurisdiction of the High Court My lord will have the Arunachal Pradesh, that act, State of Arunachal Pradesh Act 1986. Yes, yes, copies I had given, my lord. My lord, once I can have further copies, my lord. This is the one. My lord need not take that. I have further copies. My lord, we'll have a section 18, my lord, at page 7. Common High Court for Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. On and from the appointed day, there shall be a common High Court for the states of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, Arunachal Pradesh, to be called the Guwahati High Court, the High Court of so-and-so, herein referred to as the Common High Court. The judges of the High Court of so-and-so, holding office immediately before that day, shall, unless they are elected otherwise, become on that day judges of the Common High Court. So, my lord, there is nothing called a judge of the Guwahati High Court. It's a judge of all the
High Court.
area High Courts of the Guwahati High Court, and
That is why the power to place a particular judge in any of the benches or the
Now, that will be further
or vice
clarified.
versa.
Page 20, para 20, section 24, man.
Yes.
My lord, the principal seat of the Common High Court shall be at the same place at which the principal seat of the High Court of Assam, just before coming into force of, my lord, the Arunachal State. 2, my lord. The President may, by notified order, provide for the establishment of a permanent bench or benches of the Common High Court at one or more places within the territories to which the jurisdiction of the High Court extends, other than the principal seat of the High Court, and for any matters connected thereto. Now, it is under this power, as well as, my lord, the power under, I'll just give that, my lord, Northeastern Reorganization Act, this one. My lord can have this. Because, my lord, in the notification at 349, page 349, there are 2 provisions there. Subsection 2 of 24 of the State of Arunachal Pradesh Act, read with subsection 2 of section 31 of the Northeastern Areas Reorganization Act. So this is the Northeastern Regions Reorganization Act. 31 is at page 16, my lord. Section 31(2), my lord. Of the Northeastern Areas Reorganization Act 1971.
Yes.
31 is the same, 2, my lord. The President, by notified order, provide for establishment of permanent benches of the Common High Court, at one or more places within the territories to which the jurisdiction of the High Court extends, other than the principal seat of the High Court for any matters connected therewith. Now, my lord reads the page 349 notification. Correct. This is, my lord, in the form of a delegated power, my lord. This order may be called the Guwahati High Court Establishment of Permanent Bench at so-and-so Order 2000. There shall be established a permanent bench of the Guwahati High Court at Itanagar, and such judges of the Guwahati High Court, not being less than 1 in number, as the Chief Justice of that High Court from time to time nominate, shall sit at Itanagar in order to exercise jurisdiction and power for the time being vested in the Guwahati High Court in respect of cases arising in the state of Arunachal Pradesh. So, my lord,
So the power is vested in the
Guwahati High Court.
It is just being
It is being just for the
designated for the time being.
My
Yes.
lord, by judges who will be notified by my lord from time to time. They will exercise the power of the Guwahati High Court sitting at the permanent bench in, my lord, Itanagar for matters which will arise within
So the jurisdiction is also subject to that time capsule which is provided under this clause.
Lordship.
Yes.
Now, my lord, will have the proviso.
Yes.
Provided that the Chief Justice of that High Court may, in his discretion, order that any case or classes of cases arising in the state of Arunachal Pradesh shall be heard at Guwahati. So, my lord, it can be a particular case
Or a class
or a
of cases.
class of cases. And here, my lord, this jurisdiction being the power, my lord, I'll use that word, the master roaster is also coming in here, that my lord did not assign any reasons. I'm not sure, my lord, that the High Court Registry was magnanimous in giving that, my lord, RTA reply. That ought not to have been given. If
There was
it
no
was not
requirement.
given, it would not have been, my lord, in violation of the RTA Act.
Yes, yes.
So, my lord, my humble submission is, my lord cannot change the cause of action for filing a case before the Arunachal bench, but my lord can always have this jurisdiction to transfer a class.
So where the matter shall be heard.
Where the matter
It is
shall
only,
be heard.
it's only a matter of convenience
Convenience.
that the matter is ordered to be heard at a particular place.
Place. My lord. And that
And
is
that
clear.
too, not in any other bench, only at the principal seat. That discretion is guarded
Guarded, my lord. At Guwahati.
at Guwahati. It
At
can't be that chief justice that let hear it at Kohima.
No.
That
my
is
lord,
not
will
permissible.
So this
So the-
itself shows that if the Honorable Chief Justice finds that there is a necessity, which is a satisfaction he himself have to draw, my lord. It is not a
Basically, Mr.
satisfaction
Nair,
which has been
this clause 2
lordship.
clearly prescribes that the jurisdiction is in Guwahati High Court.
Guwahati.
But cases arising in that, we may assign judges to hear those cases in the benches.
So for that assignment of the judges, my lord, there is required to be a seat
Yes.
or a bench.
Bench.
So a bench is
Bench
there.
is constituted. Yes.
And my lord, one more thing, that 41, notification number 41 has got nothing to do with this, my lord.
That is,
My lord, there were cases pending here. Or my lord, there is no bench,
No
appropriate
bench
bench
there.
available. Matter is filed here.
yes.
Wherein
Then
my
they would-
lord is not exercising the
the power
jurisdiction of
of
the proviso.
under the proviso.
So my lord says that
Automatically
all those
go.
matters will go back.
Automatically, it is just as if a new district is carved out.
Lordship.
So all cases which are pending in the original district, they're sent
Goes
there.
back. And even if, my lord, there is no appropriate bench, my lord can pass in an appropriate case an order to file and move the matter here so that the litigant is not put to
Litigant,
difficulty.
yes.
But that order not being under the proviso to, my lord, this notification, that cases will go back.
Go back ultimately.
So
When the
there is
bench
no further order required from my lord.
Yes, yes.
So in my humble submission, my lord, this is a misunderstanding. I still hope, my lord, that is to be clarified, my lord.
We'll do that. All right.
Much obliged.
Arguments heard. or- ये लगा देना सर एक वो वाला ऑर्डर की कॉपी सब लगा दीजिएगा यस प्लीज
Deliberations, my lord, I am not pressing the interlocutory application. The interlocutory application was for impeachment of NHPC so that we can protect our.
NHPC the transfer has not been made on the request of the NHPC
No.
so you are not required to be heard
We are not pressing.
you are not required all right
Okay.
I am not pressed
Much obliged.
Grateful.
thank you ना लगा दीजिए
Item number 16.
Lordship, here on behalf of respondent number 1, today we have filed our additional affidavit enclosing the inquiry.
inquiry report
Yes.
we have given you 3 dates for this Mr. Chaudhary
Lordship,
please don't roll over the files in this manner on the last date you said that you will be doing it in 1 week that was on 26 July
yes, Lordship, there was, it was on my call, Lordship.
Mr. Chaudhary submit that he has filed the inquiry report on
Already
record along with an affidavit today. Copy thereof,
I have received a copy, madam. I need to file rejoinder, man.
copy thereof has been provided to the counsel for the petitioner who prays for and is granted. 4 weeks time to file rejoinder counter to the forced affidavit and inquiry report. List of 4 weeks.
Obliged. Item number 19 and 20.
Lord, I sincerely apologize, my lord, but can we kindly be accommodated for today, my lord? Because Mr. Leedas, who is appearing in this matter, my lord, he had to urgently go to Itanagar. my lord.
It is stated that arguing senior counsel Mr. Das is not available today because of some personal difficulty. A request is made to adjourn the matter by Mr. Botakura appearing on behalf of petition. The other side has no objection. list of 4 weeks. Both of them will go. Who's there in the other matter? Mr. PJ Fukan, you are appearing for the other appellant.
Item 20.
Sure, claims, there is a counter appeals.
No, my lord.
Then you have same interest, same cause of action.
My lord, there are two parts, my lord. One is regarding selection, another, my lord, my lord, severability, doctrine of severability, my lord. That application of doctrine of.
Okay, list of 3 weeks as played.
Most of it.
Item number 21.
This case, my lord, I prefer further weeks time, my lord, to file an additional affidavit. We have not prepared it, but then the petitioner.
What is the prayer in your petition, sir?
My lord, it is about, my lord, a fair challenge and notification, my lord, where certain administrative units of this, my lord, some villages, where we are shifted to another, my lord, district, my lord, causing us, my lord, inconvenience. My lord, and in the meanwhile, the delimitation process came in, my lord. And my lord, delimitation process, my lord, has its, my lord, initially it was proposed for Algapur, my lord, then it has been, my lord, given to Hailakandi constituency, my lord. But we'd like to distinguish that process, my lord. Therefore, we are filing additional affidavit, my lord. It could not, it was been prepared, but he could not come because of some difficulties. My lord, I pray a week's time, my lord. That was.
Swata appearing for the petitioner's praise for and is granted further opportunity of 3 weeks to file an additional affidavit. List of 3 weeks.
Item number 22.
Yes, please.
Thank you, Lordship. My lord, this relates to the opening of an architect institution, Lordship, for enhancement of fees by issuing a letter, Lordship, page 50 of the petition, Lordship. My only legal question is that whether approval of the central government as per section 45 of the Architect Act is necessary, Lordship. And
Yes.
very recently I come across one minutes of their meeting, Lordship. In that meeting, Lordship, they have also, may I supply the copy of that to Lordship? For Lordship, approval of the central government on council's proposal for enhancement of fees being charged by the Council of Architect from Architect. Council noted the information as detailed in this agenda and decided that the MHRD be requested to consider the proposal of the Council favorably. But Lordship, the central government also, Union of India, in their affidavit also categorically stated page 207 of my petition, Lordship.
Yes.
May I read, Lordship? 207, Lordship.
What were you reading from these minutes? Minutes,
Lordship. It was, I have supplied the copy of that to Lordship. Clause for page 20, Lordship. In the minutes, Lordship, that not annexed in the repetition.
Clause 4.
4, Lordship. Page 20, Lordship. That just now I supplied the.
Yes, you have supplied. What are you reading from that?
Lordship, regarding approval of central government on council proposal for enhancement of fees.
So the council has forwarded it to the central government. What is your case? That central government has not approved?
Not approved, which already found by this Union of India, Lordship, in their affidavit, page 207, Lordship. So without approval, Lordship, they cannot, Lordship.
Is it required? Is it required?
Lordship, as per section 45 of the Architect Act.
Who is appearing?
My senior Mr. Mohanto appears, my lord. He is in lacking court number 5, my lord.
Lordship.
Yes, then we'll admit the appeal, Mr. Masunda.
Lordship, little bit urgency is there, Lordship. I pray, Lordship, that to be.
Who's appearing for the Union of India?
Mr.
Chaudhary?
Last occasion appeared, Lordship. I already served the copy, Lordship.
All right. What is your stand in this case?
Someone else appeared here, Lordship.
HP Gupta.
Gupta. Already he appeared on. And he has filed also his affidavit in that.
Where is Ms. Gupta today? Is his name appearing in the call list?
Yes, Lordship.
Yes, it is there. Call him. We'll pass it over then. Pass on.
Password for the day.
For the day.
No, Lordship, sir.
For the day, there is nothing like password for the day. If you want, it will come up in a while.
Lordship.
All right. Mr. Mazumdar, if you want, you can bring these minutes on record. Perhaps then they will be
Lordship,
warned
I
about
will
this.
be allowed to file.
Mr. Mazumdar, place for it is granted 2 weeks time to place on record copy of the minutes of meeting related so and so, whereby comma the Institute of Architecture,
Lordship.
the
Council of Architecture.
Council of Architecture sought approval from the MHRD for enhancement of fees being charged by the Council of Architecture from the architects. This is from the architects.
Lordship.
It doesn't deal with the institute. You are
I am for the institution, Lordship.
all right.
They impose 25 lakhs.
He
Lordship,
submits that the said request was not approved by the central government.
Lordship.
The minutes be brought on record within 2 weeks. Then counsel for the respondent for appearing for the COA may respond to the submissions so made by filing an additional affidavit if so required within 2 weeks thereafter. Re-notify on 28th September.
Much obliged.
Item 23.
So this is the matter relating to Competition Commission. On the last occasion, we already lost directed us to serve the copy on the ONGC. But on the grounds on which the judgment of Learned Single Judge was challenged, then the Learned Single Judge was considering the interim prayer and rejected the interim prayer, but while rejecting the interim prayer, notice was issued and the affidavit was directed to be filed. But the Learned Single Judge went into the merits of the case entire while rejecting the interim prayer. The 3 grounds which I asked before on the last date, that the decision of the Supreme Court in the Rajasthan's case was quietly applicable in my case, but the same was said to be that the facts were different only on the ground that in that case the matter was carried to the apex court after the final order was passed and after the tribunal decision. But my submission before Lordship was that decision being binding under 141 of the Constitution, it cannot be said that the same will not apply only because the matter was carried to the Supreme Court after the order of tribunal. Secondly, the complaint being filed for the year 2013, 15 and 17 in the year 2020 only. And the delay in filing the complaint has not been explained that why it was sent, because after 13, the 15, the tender was, they were allowed to participate. In 17, they were allowed to participate. And thereby, the limitation which were provided in the subsequently in the statute of 3 years, that cannot be constituted, that it will be applicable only prospectively, because earlier also the Competition Commissioner observed that the delay must be explained. And thirdly, in any case, the director.
All the commission has asked you is to supply the documents. What else? To initiate an inquiry. Whether that inquiry, if it is a time barred one, satisfy us. Otherwise, what is the embargo on them to conduct an inquiry?
Under 26(1), the order can be directed for further inquiry only when the commission prima facie comes to conclusion. Now, prima facie, when there was judgment of directly by the Supreme Court on the same issue, that when the limited suppliers and limited purchasers are there, then similar prices cannot be ground that there was the price beginning or calculation. Now, it was placed before the Learned Single Judge, and the Learned Single Judge simply held that this judgment is not applicable in the present facts, because in that case, the matter was carried to the Supreme Court after the final order was passed and the tribunal's order. The law which has been laid down by the apex court cannot be said that case will not apply, because in all cases it cannot be said that they must go through the entire channel and then only the law will be applicable. That cannot be the ratio.
Normally, that is so, Dr. Saraf. In criminal trials, the principles which are laid down at the appellate stage they do not apply to the stage when the charges are being considered. So the same analogy would apply.
Well, the appellate stage, and in this case, when somebody comes to prima facie case, and when there is a decision of the Supreme Court.
Prima facie case and a case to be decided after receiving evidence, the situation would be entirely different.
Prima facie case, when somebody comes to conclusion, and when the judgment of Supreme Court is there, the judgment of Supreme Court, it cannot be said that that decision, on the basis of that I will not come to a prima facie case.
All right, let us see the Supreme Court judgment. What is the observation, whether it is based on appreciation of facts or only at the stage of initiation of proceedings, the same ratio would apply.
Subject to your last also, the learned single judge, while rejecting the interim period.
At best, we can say that your writ petition will be decided expeditiously and without being observed by without being prejudiced by any of the observations.
That will be better course of similar. That will be best course of action. Lordship also proposed on this day.
So we will say that, but no stay.
But till then, if action is taken.
What action? You will only be required to give information, that's all.
The information you also see, it has been said, Milord, that the information when 26(1) order is passed, Milord, that is a serious consequences on because the reputation and the company that the Delhi High Court has said, and all throughout for 2 years, 3 years, Milord.
So that would indirectly mean staying the proceedings, sir.
Milord, the 2, 3 years.
Accepting the appeal on merits.
Well, after the writ petition was heard, Milord, writ petition was filed. For 2 years, there was assurance by the respondent that no action will be taken, and no action was taken for the last 2 years. Now.
The writ petition is of 21.
21. Yes, and from 21 to 23, Milord, when the matter was heard, no action will be taken on the assurance that the action will not be taken.
Was it recorded? That
Milord, it was by the additional Solicitor General, the assurance was given. And the matter was, Milord, ultimately it remained pending for some reason or other, Milord.
No, the writ petition was filed in 22, sir, not 21.
22.
Yes.
It was heard, Milord. And thereafter for 1 year.
And you, Dr. Sarar, you came to this court by way of the writ petition. Order passed in 2020. You also challenged the order after 1.5 years.
What I came, why I came, the order copy, I mentioned, the certified copy, etc. we were applied for, they were not supplied. Once the order copy was supplied, because I cannot challenge unless until the order is supplied. Milord, the question is that, Milord, only. I have no objection, Milord, if the matter is heard within time framework. The
time framework, we can't say, we can only make a request.
At this stage, Milord, once the matter for 1 year more so, Milord, on the assurance, Milord, it was kept pending, Milord.
Who gave the assurance? Let us
know. No harm will be caused.
Who gave the assistant, the deputy SGI? Who was appearing? Now who is appearing?
Now he is appearing, earlier the additional solicitor appeared, Milord. And they also filed an affidavit that since the matter, the order was not passed, and thereby now our undertaking which was given to the court, because the matter, Milord, for some reason or other for 1 year, the order did not listed. So they said that since the matter is not listed and we will withdraw the undertaking. But again, Milord, before the single judgment matter was heard, that undertaking was given. So my Milord submission for lordship there, Milord, when the matter was proceeding like that, Milord, nothing harm will be caused unless until.
This is not the concept of that harm will not be caused. That can't be the concept. The issue is that the learned single judge has decided a matter after considering the entirety of facts. So can we set the order at naught without examining the validity thereof?
This is only interim.
So that if we pass an interim order, that will be setting the order at naught.
No, the interim order, your lordship, unless and until the finally, if the merit on.
All right, then argue on merits. We will hear you. Whether the order is required to be interfered with. This is an intra-court writ appeal against an interim relief order. So generally, the principle is settled. No interference.
I fully appreciate when the interim application is there, already passed, and when the matter is carrying.
Normal course, this doesn't happen.
Normally, there is nothing. I am not.
If you can make out a very strong case for interfering in the order, perhaps yes. So argue all right. We will.
I will submit first, Then when the complaint, the tenders are 2013. 15 and 17, and the information is supplied in the year 2020, and no information, no reasons are given that from 2013 to 2020, why for 7 years the information was not furnished. And
who is the complainant?
ONGC.
ONGC. What have you said about the delay?
They have not said anything, Milord.
They have filed their affidavit in the writ.
They have not filed affidavit. They have not participated in the proceedings, and I will submit, Milord.
What is your stand in the single bench? You are not filing an affidavit even.
But the issue of imitation does not arise. The learned single judge has dealt with. The amendment that was brought in was only brought in 2023.
We understand, but it has to be within a reasonable time. It can't be an indefinite leeway to the complainant to approach the commission at any given point of time.
But the tenders otherwise, the year 2020, even 18.
18, all right, leave apart 18.
18,
18 is all right, but what about 17, 18 we can ignore, but 13, 15.
The judgment should still for 10 manner. Even 10 manners, 10 years history of quoting identical prices and manners, anti-competitive bidding, but also getting. That judgment should be like you are. Para 24, so let's look at the debt with that.
Let's see.
Page 218. Where is the case where there was
Hmm. Yes. The delay aspect Excel Corp goes against you, Dr. Saraf. Don't ask the division bench to give an opinion which may harm you in the merits of the matter.
Just subject to the Excel here, I never said no 26-1 order is administrative order. There's no dispute about it. But why learned friend is saying that for 10 years they were quoting the similar prices. 2013, when we quoted, they were aware, 15 they allowed to participate. The 15 they were aware and they allowed to participate 17. Suddenly, in 2020, can they say that for 2013?
Your opportunity when the matter is finally taken up by the commission, or else even the writ court still, you have that forum with you. So, but I'm not inclined to interfere.
My submission for lordship is there.
Yes.
The commission also in their earlier orders clearly observed that it must be explained. I will just place before lordship.
That would be when they go into the merits of the matter.
About limitation, they said that you cannot file the complaint at any time you like. You'll also see para 67.
Para
67. And this before parting with the order, the commission also observes that the lease juris referred to in the instant period dates back to the earlier 2010, October 2010 and June 2014, and information have offered no justification reasons for approaching the commission at the balloted stage. Thereafter, in another case, my lord, you'll also really see. They have clearly said, my lord, in yes. Another case, my lord, para 99. Para 99 of the next order, my lord. The concept and application of the principles of limitation delays laches in institutional inquiry at the hands of the information provider is wholly out of context with the case of inquisitional proceedings as against the adversarial proceedings provide law. This is, however, not to suggest that the informant can walk in at any stage by taking up bilaterally their cause. The commission is fully entitled to examine the justifications for approaching the commission at a bilateral stage and on a holistic examination of the regions and in the light of the duty enjoined.
Saraf, it is a case wherein after making the observation over a period of years, that they decided that yes, there is a rigging going on regularly, then they were compelled to file.
2015, it was pointed out to them, it was pointed out to them that they are putting similar prices. In spite of that, they have not taken action. They are 17, they are allowed to participate. 18, they are allowed to participate. And 2000 suddenly.
So ultimately, they must have realized that this is happening too regularly. Frequently,
somebody realizes after 10 years, after allowing everybody to participate.
This is not for a solitary year. Had they filed a complaint only for 2013, it would have been a different thing. But now they are incorporating the entire period, wherein they are trying to project or demonstrate that over a period of 6 years, 7 years.
A commercial transaction, wherein the tenders are invited. And 13, 15, 17, 18, they go on continuing allowing it.
You will have that opportunity to satisfy the single judge or the tribunal as the case may be. But prima facie, we are not inclined, sir.
For the subjective or not, the question which I'm making, my lord, I fully appreciate that in the interim matters, your lordship, generally.
This is just
Very
a
well-
very reasoned order.
No,
There's no
region
reason.
order, you know, region order, but at the
We'll
stage.
just observe that the observations, the writ petition will be decided without being prejudiced by the observations.
So that, but well, in the meantime, at least, your lordship, at least.
That would be indirectly accepting your stay
Your
application, sir.
lordship may at least direct them, well, subject to your lordship, that at least the inquiry should be for the time being limited to 2018, 17, 18. At least, well,
We'll
the,
not make any
well,
kind of,
if otherwise-
you can again, you can file a second stay application. If you are going into that,
Well,
file a second stay application.
well, that,
If you want to limit the inquiry to a particular stage, you may move a second
that
step.
was, and further, my lord, the DG which is making the inquiry, he can make the inquiry only for the years which is related to from 2013 and 2018 only.
That would be interfering on the merits.
Well, that will be, well, on that case, well, the Delhi High Court has stated the proceedings that he cannot make a roving inquiry. Well, if he is making inquiry from the very inception of the company.
That is to show conduct over a period of years, sir.
Well, the
Sir,
conduct,
no two cases can be same.
well, conduct from 13 to 15 only now.
Oh.
His conduct cannot be from the date of incorporation of the company. 13, the tender was there. How
That
the-
argument you have to advance before the single judge.
So single judge advanced, but that has not been considered. At least, my lord, he cannot go beyond the, my lord, the tender, when 13 tender is under question. How he can go from the information from the very beginning?
Let's see, where is that ground in your writ petition?
Your
And
petition.
where is that argument before single judge? Let's see the argument before single.
No, lost. Page is single judge. This patient was here. You'll also see at page 71.
Para of the order.
Well, perhaps the order is saying, my lord, but I'm showing the petition below the grounds which were taken. Just below para 27 below. Page 71.
Yes. Hmm. 71, what do you want?
71, you'll also see I have stated the respondent 3 has gone beyond the scope of the impugned order and is conducting a robbing and fishing inquiry. Thereafter, you'll also see, my lord,
So, all right, you go to the commission and make an application
commission at this
that the
stage-
Director General is making a rowing inquiry
at this
beyond the scope of the order.
At this stage, I was looking to go to the commission because the order has been passed it is only after the inquiry conducted. Then the commission will give the hearing. Before that, nothing is there.
So, all right, that merely because yes, don't give the information. Don't give the information. Can he take coercive measures?
Yes, the coercive measures are there. Search and seizure, everything is there. At least my lordship may.
The action of the director is not even under challenge in your writ petition.
Well, the-
Read the prayer where the action of the director is under challenge.
Your lordship.
Read the prayer clause. It's not even there.
So your lordship, see, 8/11,
Hmm.
8/11/2021,
Prayer, please.
at page
Order.
83.
That is the order of the commission.
No, 8/11/22 is the director general.
Let's see, where is it? Page number?
Page number, I'm sure. 8/11, director general. Correct, Chair? So the order. That was the director general.
Where is it? Let's see.
So that is, you'll also find at page 193.
Brief profile. Brief profile, what is the problem?
So this is the order by the director general,
Hmm.
and he asking for the information. I can ask below to understand that for the years for which the tenders were in examination, he can ask for the
Brief
information.
profile of the company.
Not profile of company, you're asking for the similar, not profile of company.
But this was not the argument, Dr. Sarab. You can always make an argument. Give the information which is relevant for the years concerned and then ask him to hold back the others. That argument can always be raised before second. Not inclined, sir. All right.
But at least you'll also object, my lord, that the information, my lord, for the relevant years, at least is provide. Otherwise, my lord, they will ask for course elections. At least that's
No,
what, my lord.
you can always say that, no, we are not parting with this information. This is available online.
That liberty
Search
may-
it online.
Some liberty may be given to me. Otherwise, my lord, they will start for the coercive measures.
Oh, Director General has got coercive measures powers.
For the
Let
search
us see.
incident.
Let us see what power.
Search incident power. Yeah.
Who appears for the Director General? You are appearing, Mr. Mahanta?
Yes, ma'am.
Yes, let's see. Why this roving inquiry? You can make an inquiry regarding the years in question.
My lord, that.
What about when it was incorporated? What your directors do? Where do they live?
Even in a purposeful judgment, information of last 10 years also, man, they can raise a power. Lord, it is in very preliminary stage, my lord. And there are three, my lord, other, my lord, they are participating, my lord. In the same
Other
complaint,
three
there
are
are
participating, there is no
two
question.
company also. They are participating, then because of his non-participation, my lord, it is unable to.
You know, other two
conduct.
companies are participating,
So,
that
my
will
lord,
not make.
Let's see the scope of inquiry then. All right. Dr. Saraf, then you will compel us to make observations which would prejudice your writ
My lord,
petition.
I will never
So
like.
That's basically,
Well, I only
we are
like-
not inclined. This is
I only
interim
want
stage.
some-
Get your writ petition decided on merit, sir.
My lord, at
Till
least,
then, you can, the litigants always have measures how to dilly-dally the things. You don't need our comments on that. No,
at
nobody does it without his desire.
well, at least liberty may be given to me to approach the single judge for the,
Expeditious hearing of the writ.
also for the seeking for the prayer, making prayer for the, my lord, the interim, that Director General, my lord, at least.
We'll leave you to file a fresh stay application for particular submissions which may not have been noted. We can observe that only, nothing beyond that.
In my humble submission, at least, my lord, that 2013 to 18, not beyond that, my lord, at
We
least.
can't go on hair splitting exercise, sir. Now this. All right, take down, order is out. Page 24 is same.
No, it's, here the petition is challenge section 16(4) of GST Act. We have not filed our affidavit yet. In the meantime, what's the Andhra Pradesh High Court has passed a judgment dismissing the writ petition upholding the section 16(4) also.
Dismissing the writ petition.
Yes, sir.
Let's see. Item number 24.
Well, I've gone through the judgment. There's no doubt that it was against me. But I think, my lord, in a day, instead of 2, it may come up after some days, my lord, so that you'll also be passed.
Okay, Mr. KL has placed on, drawn the court's attention to the judgment rendered by Honorable Andhra Pradesh High Court
This is following the Supreme Court judgment, my lord.
on the based on the Supreme Court judgment in the case of Union of India Ganpati Dilcom.
No.
Then?
Earlier, my learned friend placed it.
ALD.
ALD Automotive versus so and so. He urges that the controversy raised by the writ petitioner in this writ petition is squarely covered by the ratio of the aforesaid judgment. Dr. Saraf, please for some time to complete his instructions. List after 4 weeks.
My lord.
Much.
The judgment निकाल के दे देना मुझे सारे. Send all the judgments inside. एक बना देना GST करके और heading लगा देना.
Malad, here item number 25, 26 and 27. So appeal preferred by the state, Malad. Appeals are otherwise admitted, Malad. And I have to take steps on some answer notice on the
Appeals have
some
been
respondents,
admitted.
Malad. Yes, Malad. So I'm due to inadvertence, Malad, I could not take steps, Malad. So
These are those drop teachers matters or what?
no, there is a special TET matters, Malad.
6
Why
years,
they have
my lord.
listed for admission and when we have admitted the appeals?
6
maybe
years,
one-
my lord, elapsed, my lord.
Should be
6 years elapsed, my lord, this pending tendency of this.
All right, but once the appeals have been admitted, why?
listed for orders, Malad, but
Let's check.
yes, Malad.
It must be one of the appeals may not have been admitted.
16/6/2023 order, Malad.
16/6 देखना भी. Service is pending on some of the respondents.
Exactly, Malad. So I'm praying for 3 days time to complete.
Just
it,
let's check. Uh, the connected two appeals have already been admitted. Thus, the instant writ appeal, writ appeal number 304/18 is also admitted. You are presenting which respondents
I am respondent number 1, my lord.
and the others? You're not representing? Two, just hold on.
This writ appeal number is 211, my lord.
No, 304/18. Anupama Bora, Jugal Chandra, Laskar, Utpal Kumar Das.
No, I am not.
Steps for service upon the respondents be taken within 3 days.
Yes.
Whereafter process be issued to such respondents. List with corrected writ appeals. उनमें देख लीजिए सर्विस हो गया क्या? In case, comma, steps for service are required to be taken. In case any of the respondents in the corrected writ appeals have not been served, comma, steps service shall be taken for them also. Check कर लीजिए. Steps not taken. Same order कर दीजिए ना. Step उसमें admit करने की जरूरत नहीं. 211, 2 are represented now.
Yes, my lord.
1 and 2.
Yes, my lord. Here only we are 2, my lord. Yeah, my lord. 211 we have already.
211 में हाजिरी लगा दीजिएगा, इनका अटेंडेंस लगा दीजिए. So and so for the responsible. 1 and 2. Steps for service on the unserved respondents taken in 3 days. We'll have to process the issue. Same way check कर लीजिएगा. 183, no one appears.
None appears.
183.
None appears, my lord.
All right, steps of service on the unserved respondents be taken in 3 days. We'll have to process the issue. Rule is made returnable in 6 weeks.
182.
Respondent.
Aditya Lodge. Obliged Lodge.
Obliged.
Supplementary list, item 31.
In this case, on last lordship, I could not appear lordship due to my daughter was in lordship. That is why I filed lordship exemption petition for respect number 3 and 6 lordship.
Filed. What have you filed?
Lordship.
Exemption from personal appearance.
Yes, madam.
Of the respondents numbers 3 and 6.
Yes.
They are contemners.
Yes, madam.
What is the order under contempt?
Order line, my lord, can you see page 13 lordship? Page 13 lordship in my IA.
30 वो देना contempt petition then.
Well, since the respondent of contempt number 3 and 6 are not present in the court, nor their counsel has appeared today, these officers shall be intimated to remain personally present in the court on the next day of listing.
Yes.
My lord, I have already filed lordship affidavit lordship in the month of February.
आइए में लिखे. And counsel Mr. Your good name?
A. Hussain.
A. Hussain has moved the instant interlocutory application seeking making a prayer for exemption from personal appearance of the response numbers so and so in the contempt petition. Full stop. It may be mentioned here that on the previous date, that is 19/7/2023, comma, as no one appeared on behalf of these respondents when the matter was taken up, comma, we had directed the officers to remain personally present. Mr. Hussain submits that his daughter was ill and thus, comma, he could not appear in the court when the case was taken up. In the circumstances noted above, comma, the direction given requiring personal presence of the respondents number 3 and 6 is hereby recalled. What about compliance? Compliance report.
File affidavit on behalf of respondent number 1 and 2 is being filed today, man. Actually, matter was listed for tomorrow, my lord. It has come at his instance.
Okay, list the contempt petition tomorrow. List the contempt case tomorrow. The date already, list the contempt case on the date already fixed, that is 29.
Along with the affidavit, my lord, that we are filing.
Affidavit लगा दीजिएगा सर. दे दीजिए. आइए डिस्प्ले.
Passover meter, item 629.
Yes,
Yes,
Mr. Nayak.
Lordship, at this stage, Lordship, we are concerned with identification of new state vending zone.
Vending zones.
So far, the instruction I have received from GMC authority, Lordship, so far they have received 12 positions from their respective councillors, Lordship, and 44 identified by the Street Vendor Association, Lordship. Now, this list has been forwarded to the concerned administrative department, Lordship, but the town vending committee, which is not presently
It
continuing.
has still not been constituted.
Yes, Lordship. That is,
So how long will it continue, Mr. Nayak?
that is what we are waiting for.
Till then, all these vendors will continue to trade heavier in a absolutely unorganized manner.
Yes, Lord.
Yes,
Yes, that is there, Lordship.
then how long? What is the procedure for constituting the
Lordship, it will be
committee?
constituted by the Department of Housing and Urban Affairs.
How long will they take?
Lordship,
Department is a party in these petitions, in this. No.
no.
Not a party. Mr. Botakur, then without the committee being constituted, how the vending zones will be finalized?
In fact, your lordship, earlier vending, town vending committee was constituted.
It was there, Lordship. Now it has.
Its tenure has come to an end.
Okay, now they will have to, your lordship. And in fact, your lordship, what has happened, your lordship, because of all these vendors are doing business in an unorganized manner. And eviction, your lordship, without following the mandate of this particular act, your lordship, is going.
Eviction is not there. They may be asked to shift their business
But your
to
lordship,
proper.
it's
But Mr. Nayak, this has to be taken care of. Can't be done in this.
Lordship will take up.
You have to provide them the place,
Lordship.
right? From Olga Terrace, Supreme Court is saying so. That provide them with the proper place of doing business.
Lordship. Lordship.
They are
may-
self-employed people.
Yes, Lordship may allow me some time, Lordship. In the meantime, I will have some instruction from the.
Mr.
department.
Nayak, place for and is granted further opportunity of 3 weeks to place on record a concrete proposal for the vending zones in terms of the earlier orders. Re-notify on the steps for constituting the town vending committee shall also be taken expeditiously. Copy of this order shall be conveyed to the concerned authority
Lordship.
forthwith. And Mr. Nayak shall ensure that the copy of this order is conveyed to the concerned authority forthwith, re-notify on 20th September.
Lordship.
Item number 10,
May it please your lordship. Lordship, I'm appearing on behalf of Senior Government Advocate Dean of my lord, his annual lordship, but he has received instruction from the respondent number 8, my lord. Some time may be granted to file the affidavit, my lord.
MS so appearing for Mr. Dean of senior council, standing council. Place for and is granted. Further opportunity of 3 weeks to file affidavit on behalf of respondent number 8.
Lordship, I'm deeply
List
obliged, my
up
lord.
3 weeks.
Obliged, lord.
Part matter, item number 1 to 3.
Yes.
The other day, the last issue which raised before this honorable court was whether in terms of the fee structural committee lordship and the 2018 act, whether director will have still some power or not. I have found one judgment, recent judgment of the honorable Supreme Court on that.
Yes.
And where in two particular areas, the director can also act on behalf of the state of Assam in spite of having a fees regulatory committee and fees revision committee.
Okay.
That judgment, lordship, I would like to place 2021 10 SCC, page 517. Indian School versus State of Rajasthan. during the COVID time, Lordship, the director of Rajasthan Lordship, he passed an order to reduce the fees. In spite of having a regulatory body under the 2016 Act of Rajasthan Lordship, whether that was put to challenge. And the Honorable Supreme Court set aside the order, Rajasthan High Court also set aside, and there was some challenge to some provisions of the 2016 Act. So I'd like to place 2-3 paragraphs from this judgment, where on a very limited area, the director can, because in our rules, only director said that he can look into that aspect under the management scheme. So in this case, Lordship, the paragraph will be 2021 10 SCC page 517, paragraph 108. (108) to 113. May I place it, Lordship?
Yes, sure.
108.
Yes.
Although, have Lordship got it? Although the stated orders made no reference to the source of power under which it had been issued, 4 different perspectives have been invoked by the state to justify the exercise to that power. First, it is competent to do so under Section 18 of the 2016 Act. In our case, it is Section 17. The state government has power to issue directions. First, it is competent to do so under Section 18 of the 2016 Act itself. Second, being a policy decision, it could issue an executive direction to mitigate the concern of the parents in exercise of power under Article 162 of the Constitution. Third, such power can be exercised by the state government for mitigating the concerns of the parents and for capacity building of the stakeholders as one of the measures under the 2005 Act. Lastly, such direction could be issued also in exercise of power under 2020 Act by the state authorities. Now we proceed to regarding 110, power to issue directions. Parameter provision is there in our Act also. The state government may issue to any school such direction or special direction consistent with the provision of this Act and the rules made thereunder, as in its opinion are necessary or expedient to carry out the purposes of this Act, or for giving effect to any of the provisions contained therein, or in any rules or orders made thereunder, and the management of the school shall comply with every such direction. The provision of this provision does not bestow the power on the state government to issue general or special direction to any school within the state. However, such directions must be consistent with the provisions of 2016 Act and the rules framed thereunder. It cannot be in conflict with the mandate of the Act and the rules. Additionally, such directions must be necessitated due to expediency to carry out the purposes of the Act and the rules, or to give effect to the applicable provisions. If the direction issued by the state governments does not qualify these parameters, it must follow the same as has been issued in excess of power based on under Section 18 of the 2016 Act. After analyzing the scheme of 2016 Act, at least 2 aspects that are amply clear. The first is a firm mechanism has been specified under the 2016 Act regarding determination of fee structure in the form of approval by the SLFC and if required adjudication by the DRFC and the revision committee. There is no express provision in the Act and rules authorizing the stated functionaries authorities to modify the school fees once finalized in the manner provided under 2016 Act. Whereas the explicit mandate in 2016 Act is that the fees so fixed by the functionaries authorities concerned shall be binding on all concerned for 3 academic years. This is a clear indication of not altering the school fees unilaterally after it is fixed under 2016 Act in any matter for the specified period. If we may say so, if it is in the nature of prohibition or mandate to continue the same fee structure for at least 3 academic years after it is fixed by the authority concerned by under the Act. By its very nature, the direction given by the state government is in conflict with the scheme finalization of fee structure under the 2016 Act and also the binding effect thereof for the specified period of the academic year of all concerned. Thus understood, the direction issued by the state government in the form of order dated 28/10/2020 does not satisfy the twin test of being inconsistent with the provisions of the Act and also necessary or expedient for carrying out the purposes of the Act as the case may be. This was during the COVID situation. The direction was to reduce the fees. Suffice is to observe that the order dated 28/10/2020, being in the nature of direction, has been issued in breach of the preconditions specified in section 18 of the 2016 Act. As a matter of law, the state government has no power whatsoever to interdict with the fee structure, much less which has been finalized and fixed by the functionaries authorities concerned under the 2016 Act itself before expiry of the statutory period as specified. As a result, section 18 of the 2016 will be of no avail to the respondents, in particular the state government, to justify the order dated 28/10/2020. A fortiori, even after the arguments of the respondent relying upon the existence of the power under Article 162 of the Constitution ought to fail. It is well established position that the executive power of a state under Article 162 of the Constitution extends to the matter upon which the legislature of the state has competency to legislate, and is not confined to matters over which legislation has already been passed. It is also well settled that the state government cannot go against the provisions of the Constitution or any law. The subject of determination of fee structure and whether it entails to profiteering is already covered by the legislation in the form of 2016 Act and the rules framed thereunder. It is not less as if there is no enactment covering the subject or incidental aspects thereof. The 2016 Act, which in itself is self-contained code on the subject matter, not only provides for manner in which the school concerned ought to finalize the fee structure, but also declares that the fees so finalized either by consensus or through adjudication mode shall be binding on all concerns for a period of 3 years, academic years. In any case, determination of fees, including reduction thereof, is the exclusive prerogative of the management of the school, of the private unaided school. The state can provide independent mechanism only to regulate the decision of the school management, and to the extent it does not result in profiteering and commercialization. So this last line, Lordship, I am taking red towards the director's role. If we look at the management, 115. In the present case, we need not dilate on the factum of whether the director, a second regional, could have issued such a policy document in exercise of the executive power under 162 of the Constitution, which power exclusively vests with the state government alone. The fact remains that a direction issued in terms of the order dated 28/10/2020 on the face of it collide with the dispensation specified in 2016 Act. Here the situation is, in our case, the director is fortified by the statute of 2005. The state government wanted to issue that order on the basis of 3 legislation. One is that the Disaster Management Act because of the COVID, then the Epidemic Act, and the third one is, Lordship, Article 162. Here we have a parallel power under the statute of 2005. So that is the difference. So in our case, the director has a special power, statutory power.
Okay, very well.
So that is how we can overcome paragraph 115.
Okay.
In that case, there was no statutory power to the director. Here we have a statutory power to the director, and it is not in conflict.
Okay, very well.
So this is my submission on that aspect regarding regarding this clause, Lordship. I'll just indicate 572. Section 14(3). Section 14(3) says
Yes.
the director may approve or disapprove the proposed increase in fees if he is in the opinion that such an increase is necessary due to increase in the facilities provided in the institution, and may disapprove for reasons to be recorded in writing.
Right.
So therefore, that limited purpose, Lordship, the director is empowered under, although this act was there from 2006 onwards, and our act came in 2018, the statute. But even after that also, Lordship, there is no conflict.
Okay.
Lordship, I would like to, 2-3 judgments I would like to refer, but before that, I would like to place P.A. Imandar's case, because this is a 7-judge bench, Lordship,
Yes.
which was further clarifying the TMA Pice case. So 11 judges were in 2013 in Islamic Society's case, explained or clarified by 5 judges now in 2005 by 7 judges bench. Very few paragraphs here. I'll cite 16 paragraphs out of 157 paragraphs in the whole judgments. And our state legislation of 2006 is directly complying the direction issued in paragraph 155 of this judgment.
Yes, yes.
So 2005 volume 6 as CC page 537. PA Inamdars versus State of Maharashtra. So I am straightway going, not repeating almost all the similar things. I would like to go to paragraph 6 for the introduction part. Paragraph 6.
Yes.
A brief backdrop, only a small paragraph of paragraph 6. Education used to be charity or philanthropy in good old times. Gradually, it became an occupation. Some of the judicial dicta go on to hold it as an industry. Whereas whether to receive education is a fundamental right or not has been debated for quite some time, but it is settled that establishing and administering of an educational institution for imparting knowledge to students is an occupation protected by Article 19(1)(g) and additionally by Article 26(a), if there is no element of profit generation. As of now, imparting education has come to be a means of livelihood for some professionals and a mission in life for some altruists. Paragraph 89.
Then Advocate General seems to have done a lot of study. Could you find the time really? And you're good. 89, yes.
Paragraph 89. Education accepted as a useful activity, whether for charity or for profit, is an occupation. Nevertheless, it does not cease to be a service to society. And even though an occupation, it cannot be equated to a trade or business. In short, education is a national wealth essential for the nation's progress and prosperity. And for first line of paragraph 91, the right to establish an educational institution for charity or for profit being an occupation is protected by Article 19(1)(g), notwithstanding the fact that this is regarding minority. We are not on minority issue.
We are not on that.
Then paragraph 92. As an occupation, the right to impart education is a fundamental right under Article 19(1)(g) and therefore subject to control by clause 6 of Article 19. This right is available to all citizens without drawing a distinction between minority and non-minority. Such a right is, generally speaking, subject to the laws imposing reasonable restrictions in the interest of general public. In particular, laws may be enacted on the following subjects: professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade, or business. 2, carrying on by the state or by a corporation owned or controlled by the state or any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizens or otherwise. Care is taken of minorities, religious or linguistic, by protecting their right to establish and administer educational institutions of their choice under Article 13. To some extent, what may be permissible by way of restrictions under Article 19(6) may fall foul of Article 30. This is an additional protection which Article 31 grant to the minorities.
Minorities, yes.
Then going to lordship, this is 92, 110. In Islamic Academy, the majority has paraphrased the content of para 68 by dividing into 7 parts. Justice S.B. Sinha has read the same paragraph 68 by paraphrasing it in 5 parts. So this is regarding the explanation of this lordship. Coming to paragraph 111, as it was submitted at the bar that a flourish of language or just a flow of thoughts placed on paper when read in isolation gives an impression as if such is the law laid down through though in reality, even the author of the judgment had not intended to do so. A mere observation or reasoning leading to the formulation of ultimate opinion on a disputed question of law cannot be read as a ratio of the decision. Such submissions forcefully advanced at the bar have been kept in view by us while reading the several opinions of TMA Pi and Islamic Academy. In Islamic Academy, the petition applicants were private unaided institutions, minority and non-minority both, and the petitioners applicants before us are also private unaided institutions, minority and non-minority, religious and linguistic both. It was submitted that the majority opinion in Islamic Academy has, while embarking upon the clarifying the law relating to TMA Pi Foundation, not only reiterated some of the propositions of law laid down in TMA Pi, but also added something more, which was not said in TMA Pi, and the two have been so intertwined so as to become inseparable, and that has been the reasons for spate of litigations post-Islamic Academy. Justice S.B. Sinha, writing his separate opinion in Islamic Academy, has not himself chosen to say whether he is a concurring opinion or dissenting one. However, it was pointed out that as S.B. Sinha Justice, opinion is analytical, clear, and more in consonance with the majority opinion of TMA Pi Foundation. It was urged that the task was difficult and unwittingly, for the sake of aiming at brevity, certain omissions have taken place. Illustratively, some illustrations are also given. Coming to paragraph 115, having generally dealt with several legal propositions relevant for our purpose, now we come to specifically dealing with the question before us. Various issues are here, Lordship, regarding fee structure, basically reiterating the TMA Pi and Islamic Foundation. I would like to take your Lordship to 140, 113.7. Pi Foundation has held that minority unaided institutions can legitimately claim unfettered fundamental rights to choose the students to be allowed. This is regarding admission, to be allowed admission, and the procedure therefore subject to its being fair, transparent, and non-exploitive. The same principle applies to non-minority unaided institutions. There may be a single institution imparting a particular type of education which is not being imparted by any other institution and having its own admission procedure fulfilling the test of being fair, transparent, and non-exploitive. All institutions imparting same or similar professional education can join together for holding a common entrance test satisfying the aforesaid triple test. The state can also provide a procedure holding a common entrance test in the interest of securing fair and meritorious merit-based admission and preventing maladministration. The admission procedure so adopted by a private institution or group of institutions, if it fails to satisfy all or any of the triple tests indicated herein above, can be taken over by the state, substituting its own procedure. The second question is answered accordingly. Then paragraph 139 regarding fees. To set up a reasonable fee structure is also component of the right to establish and administer an institution within the meaning of Article 31 of the Constitution, as per the law declared in Pi Foundation. Every institution is free to devise its own fee structure subject to limitations, that there can be no profiteering and no capitation fees can be charged directly or indirectly or in any form. Paragraph 56 to 658 and 61 of Pi Foundation are relevant in this regard. Now regarding capitation fees, 140, that it is not permissible. 41 is also capitation fees, it is debarred. Now coming to paragraph 145. The suggestions made on behalf of minorities and non-minorities that the same purpose for which the committees has been set up can be achieved by post-audit or checks after the institutions have adopted their own admission procedure and fee structure is unacceptable for the reasons shown by the experience of educational authorities of various states. Unless the admission procedure and fixation of fees is regulated and controlled at the initial stage, the evil of unfair practice of granting admission on available seats guided by paying capacity of the candidates would be impossible to curb. 146. Non-minority unaided institutions can also be subjected to similar restrictions which are found reasonable and in the interest of student community. Professional education should be made accessible on the criterion of merit and on non-exploitive terms to all eligible students on a uniform basis. Minority or minority in exercise of their educational rights in the field of professional education have an obligation and a duty to maintain requisite standard of professional education by giving admissions based on merit and making education equally accessible to eligible students through a fair and transparent admission procedure and based on reasonable fee structure. So whatever our act is contemplating, also at the very beginning, fees should be finalized. It should be approved to a procedure laid down, and also the structure of the admission process. Then 150, Lordship. We made it clear that in case of any individual institution, if any of the committee is found to have exceeded its power by unduly interfering in the administrative and financial matters of the unaided private professional institutions, the decision of the committee, being quasi-judicial in nature, would always be subject to judicial review. Taking a cue from this, Lordship, the spirit is applicable for other areas also. It is in respect of the professional educational institutions. But in case of the other things also, like fee structure, everything is subject to judicial review. Then 155. So till this moment, this legislation did not come up. It is for the central government or for the state government, in absence of a central legislation, to come out with a detailed, well thought out legislation on the subject. Such legislation is long awaited. The state must act towards this direction. The judicial wing of the state is called upon to act when the other two wings, the legislature and executive, do not act. Earlier, the Union of India and the state governments act, the better it would be. The committees regulating admission procedure and fee structure shall continue to exist, but only as a temporary measure and an inevitable passing phase until the central government or the state governments are able to devise a suitable mechanism and appoint a competent authority in consonance with the observations made herein above. Needless to say that any decision taken by such committee and by the central and state governments shall be open to judicial review in accordance with the settled parameters for the exercise of such jurisdictions. So the outcome of this overall judgment is that this act came up in Assam like in many other states of the country.
Yes.
That act was not sufficient. So in 2018, the fee structure act was also enacted.
Yes.
Now coming to this judgment. 2017, 4 SCC page 449. Secretary Mahatma Gandhi Mission versus Bharatiya Kamgar Sena. Paragraph 48 to 54, 10 and 77. So paragraph 10 first, Lordship. On 7/10/2019, the government of Maharashtra made rules invoking its power under the provisions of various university acts, etc., prescribing a standard code providing for the terms and conditions of service of the non-teaching employees of various organizations described thereunder. The expression standard code is traceable to section 8(3) of the Maharashtra University Act of 1994, which authorizes the state to make rules providing for various aspects of employment of officers, teachers, and other employees of the universities, affiliated colleges, and recognized institutions. It further declares that when such rules are made, they would prevail over any other subordinate legislation made by any statutory authority functioning under the Act. Then the Lordship will kindly come to paragraph 39. Education is an important factor for maintaining democracy and economic well-being of the society. Therefore, the Constitution of India bestows considerable attention in the field of education. It recognizes the need for regulating the various facets of activities of education and also need for not establishing and administering education institution, but also providing financial support for the educational institutions run by private/non-state actors. Then paragraph 48. Various non-state actors, including minorities, established large number of colleges and other educational institutions in these countries, both before and after the advent of the Constitution, spanning over a period of 200 years. Certain aspects of establishment and administration of colleges by non-state actors have always been regulated by the legislature. Various enactments by or under which the university are established command that colleges should secure affiliations to an appropriate university. However, after the 42nd Amendment, Parliament also became competent to regulate the activity of education. Some of the laws made by Parliament do regulate. The All India Council of Technical Education, AICT, is one such. Employment is essentially a contractual relationship between the employer and the employees. The employment in colleges could be employment by state or by its instrumentalities or by non-state actors, because there exist colleges conducted either by state or its instrumentalities or non-state actors. Therefore, the nature of legal relationship of employment varies depending upon the employer. The basic norm, employment under state, are regulated by the Constitution. The Constitution guarantees equality of opportunity in the matter of public employment under Article 16. Article 309 declares that the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of union or state. The appropriate legislature would be Parliament in the context of employment under the Government of India, and the state legislature concerned in the context of employment under any of the states within the Union of India. Article 311 stipulates that no civil servant employed by the Government of India or by civil or by state shall either be dismissed or removed from service except in accordance with the procedures stipulated thereunder. Therefore, though employment even by state is essentially contractual relationship, such relationship is encumbered by the legal obligations emanating from the provisions of the Constitution and the laws made thereunder. It is in the context of these constitutional provisions that this court has repeatedly held that employment under state is a matter of status, but not a matter of contract. Employment under the various instrumentalities of state, either statutory or non-statutory, is subject to the discipline of Article 14, of which Article 16 is only a facet. This court in innumerable cases held that though Part 14 of the Constitution, wherein Article 309, etc. occurs, is not applicable in such employment, some of the principles underlying the provisions of Part 14 still governs the employment under the instrumentalities of the state. The expressions education occurring in Schedule 7, List 3, Entry 25 of the Constitution takes within its sweep the authority to legislate with respect to every aspect of education, including establishment and administration of educational institutions such as schools, colleges, etc. Administration of an educational institution has mainly two facets: imparting of knowledge and maintaining of necessary infrastructure for providing the venue and other facilities for imparting knowledge. To perform the twin function, manpower is required. Such manpower consists of two classes of persons, teaching and non-teaching staff. Therefore, Entry 25 must necessarily take within its sweep, inter alia, the power to regulate the activity of employment by educational institutions, whether they are established by the state or its instrumentalities or non-state actors. In view of the fact that Entry 25 occurs in the concurrent list of the 7th schedule, both Parliament and state legislatures are competent to make laws regulating inter alia the establishment and administration of colleges, either by the government, union, or state, or their instrumentalities or non-state actors, that is private sector. As of now, there is no law made by Parliament regulating the entire activities of education either in public sector or in private sector. Only certain areas of education, such as medical education and technical education in some of the aspects, are regulated by the laws made by Parliament. For the purpose of present case, we are only concerned with the technical education. So, yes, this is a general thing. What I am trying to emphasize here is that because their basic challenge is that we cannot legislate. Their whole thing is that we do not have the legislative competence to enact this act. To counter this lordship, this is a judgment I am placing.
Okay.
And the Supreme Court also says that Parliament has very limited law which are basically relating to medical education and technical education.
Yes.
In our case, it is neither medical education nor technical, it is a general education. And this CBSE bylaws is not an enactment. So for that purpose, lordship, I would like to place one judgment because they are very strongly arguing that it is a case of repugnancy. For repugnancy, what are the criteria to be fulfilled? What are the parameters? So for that aspect, lordship, I would like to place 1970, I will place two judgments, 1979, 3 SCC, page 431. This is a 5 judges constitution bench. This case provides the taste and the conditions of repugnancy. Paragraph 8, 24, 25, 28, 33, 35. Certain judgment I am citing because to counter their arguments, lordship. Although these are very fundamental things.
Yes. Para 8.
Paragraph 7 quotes the Article 254, 1 and 2. I am not repeating it. Paragraph 8 onwards, lordship. It would be seen that so far as clause 1 of Article 254 is concerned, it clearly lays down that where there is a direct collision between a provision of a law made by the state and that made by the parliament with respect of one of the matters enumerated in concurrent list, then subject to the provisions of clause 2, the state law would be void to the extent of the repugnancy. This naturally means that where both the state and the parliament occupy the field contemplated by the concurrent list, then the act passed by the parliament bring prior in point of time will prevail and consequently the state will have to yield to the central act. In fact, the scheme of the constitution is a scientific and equitable distribution of legislative powers between parliament and the state legislature. First, regarding the matters contained in list 1, the union list of the 7th schedule, Parliament alone is empowered to legislate and the state legislatures have no authority to make any law in respect of the entries contained in list 1. Secondly, so far as concurrent list is concerned, both Parliament and the state legislatures are entitled to legislate in regard to any of the entries appearing therein, but this is subject to the conditions laid down in Article 254(1) discussed above. Thirdly, so far as the list matter in list 2, the states are concerned, the state legislature alone are competent to legislate on them and only under certain conditions, Parliament can do so. It is therefore obvious that in such matters, repugnancy may result from the following circumstances. Where the provisions of the central and the state act in the concurrent list are fully inconsistent, these are the conditions, lordship. I'm going further, I'm skipping this. Coming to paragraph 24. It is well settled that the presumption is always in favor of the constitutionality
Of a statute.
of a statute, and the onus lies on the person assailing the act to prove that it is unconstitutional. Prima facie, there does not appear to us to be any inconsistency between the state act and the central act. Before any repugnancy can arise, the following conditions must be satisfied. That there is a clear and direct inconsistency between the central act and the state act. Here, my submission is that there is no central act which we are violating. And CBSE bylaws, this is not a central act. It is a law under Article 13, but it is not an enactment of the parliament. That such an inconsistency is absolutely irreconcilable. And 3, that the inconsistency between the provisions of the two acts is of such nature as to bring the two acts into direct collision with each other and the situation is reached where it is impossible to obey the one without disobeying the other. Then paragraph 25, what is the meaning of repugnancy? An obvious inconsistency arises when the two enactments produce different legal results which apply to the same facts. Paragraph 28, another citation. The important thing to consider with reference to this provision is whether the legislation in respect of the same matter. If the later legislation deals not with the matters which form the subject matter of the earlier legislation, but with others and distinct matter, though of a cognate and allied character, then Article 254(2) will have no application. The principle embodied in Section 107 and Article 254(2) is that when there is a legislation covering the same grounds, both by the center and by the province, both of them being competent to enact the same, the law of the center should prevail over that of the state. Then Lordship, paragraph 33. In the case of state of Odisha versus M.A. Talak and Company, repugnancy arises when two enactments, both within the same competence of two legislatures, collide, and when the Constitution expressly or by necessary implications provide that the enactment of one legislature has superiority over the other, then to the extent of the repugnancy of the one supersedes the other. But two enactments may be repugnant to each other even though obedience to each of them is possible without disobeying the other. The test of two legislations containing contradictory provisions is not, however, the only criterion of repugnancy. For it, a competent legislature with superior efficacy expressly or impliedly evinces by its legislation an intention to cover the whole field. The enactment of the other legislature, whether passed before or after, would be overborne on the ground of repugnance. Where such is the position, the inconsistency is demonstrated not by the detailed comparison of the provisions of the two statutes, but by the mere existence of the two pieces of legislation. Then 35. On careful consideration, therefore, the authorities referred to above, the following proposition emerge. That in order to decide the question of repugnancy, it must be shown that the two enactments contain inconsistent and irreconcilable provisions so that they cannot stand together or operate in the same field, that there can be no repeal by implications unless the inconsistency appears on the face of two statutes. 3. Where the two statutes occupy a particular field, but there is room for possibility of both the statutes operating in the same field without coming into conclusion with each other, no repugnancy results. 4. That where there is no inconsistency, but a statute occupying the same field seeks to create distinction and separate offenses, no question of repugnancy arises and both the statutes continue to operate in the same field. So my humble submission here is that as there is no other statute which we are conflicting, Lordship, the whole argument, because this is a major ground, they have two grounds, basically. One is that we do not have the competence. The previous case I have said, the Honorable Supreme Court also held that we have to do it. There is a direction in Imandar's case, which was subsequent to Pai's case as well as the Islamic Society's case.
Yes.
Now, the other ground is that there is a conflict with the central law. So central law will not be sufficient. It should be central enactment, central legislation. So CBSE is not a legislation. It is a law, and that judgment also I will place a little bit in your Lordship, that what exactly is the status of CBSE. There is another judgment of 2021 where the Supreme Court declared that CBSE bylaws are laws under Article 13.
So what would be the difference between a law and a legislation?
Law, let us look at the wordings of the Constitution.
Yes.
It starts from ordinance, bylaws, traditions. All these things will become law, but these are not enactments. May I place this? The language is very clear without any vagueness.
Let's see. Article 13.
Article 13. Law inconsistent with or in derogation of the fundamental right. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. The state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. In this article, unless the context otherwise requires, law. Law includes any ordinance, order, bylaw, rule, regulation, notification, customs, or uses having in the territory of India the force of law. And law in force includes law passed by and made by a legislature or other competent authority in the territory of India before and the commencement of this act, constitution, and not previously repealed, notwithstanding that any such law or any part thereof may be taken then in operation either at all or in particular area. So my humble submission is that law will include ordinance, orders, etc. And if we look and read this with Article 254, the chapter thereof.
Mr. Chakia, if you see 3B.
3B, law in force.
Yes.
Includes the law passed or made by legislature. Absolutely no quarrel on that. Because their law, the bylaw is not passed by any parliament or any legislature.
But
So
then-
to bring in the repugnancy point,
It would be covered by 3A. Why not?
it is
A
it will
law-
be covered by 3A.
it is-
It
yes.
is a law.
So why it will not be a law which is referable to in Article 3?
I have no difficulty on law. It CBSE bylaws is a law, but it is not a result of a legislation exercise.
Okay.
That is why Lordship, if Lordship is pleased to come to paragraph, the chapter, the heading of this chapter. Just 1 second, Lordship.
11.
Yes. Chapter, part 11. Part 11 says, relation between the union and states, legislative relationship. So this CBSE is not a legislative exercise. It has not gone through a legislation. For that, I have a this Allahabad High Court judgment.
Let's see.
I'll place it. So distribution of legislative power. So neither the parliament nor the state assembly has done anything with the CBSE bylaws. The society registered under 1860 Act, Lordship, they have formulated this bylaw. Just like our cooperative society, we have lot of bylaws. Various clubs have various bylaws. Various other organizations have bylaws. So those bylaws cannot be placed on the same pedestal like an act passed by the state legislature or by the parliament. And this repugnancy is, Lordship, related only for the purpose of, only from the area of legislation exercise.
Law made by the legislature.
So 254, distribution of legislative power, this part 9, chapter 1, legislative relations. And article 254 comes under this chapter. So it has nothing to do with any bylaws or any ordinance. Even ordinance are not legislature. Although the governor issues the ordinance. Unless and until an ordinance is placed before the assembly and there is a debate and it has been finally accepted as an act, till that moment it will not become a legislative exercise also. So that is why ordinance, when the ordinance is issued, an ordinance is issued when there is no assembly session, no parliamentary session. During that gap, normally we find if the government feels that a particular law has to be framed or brought into force, then if there is no assembly session or parliamentary session.
Let's come to 254(2) once.
Yes.
Whether it refers to only the law made by the parliament.
Yes, Lordship. Yes.
Let's see the split
Yes.
of the language.
Yes, language is very clear. The other day I placed it
Article
once,
2.
I am placing it once more.
Yes.
Heading would Lordship will kindly take inconsistency between the laws made by the parliament and laws made by the legislature of state. We have to
Heading
read
gives a
the,
general indication, but heading cannot govern the language.
yes,
of the
I'm coming
section.
to that also.
Come to that.
But we have to first get an indication under what heading it is there.
Of course.
Yeah.
Come to the
Two.
provision. Yes.
Where a law made by the legislature of a state
Mhm.
with respect to one of the matters enumerated in the concurrent list contains any provisions repugnant to the provisions of an earlier law made by parliament
By the parliament
or an existing law with respect to that matter.
So it talks of
That
a
matter
law
means-
made by the parliament or an existing law with respect to that matter. Now, if we reconcile Article 13 and your own statement that CBSE regulations are law, but they are not made by the legislation. So if we see this provision,
Yes, Lordship.
then it talks of both,
Yes.
either law made by the parliament or an existing law with respect to the said matter.
Yeah, here, the interpretation of the Supreme Court, that judgment I have said, there should be two enactments. We have to, these are interpreted subsequent.
Yes, of course.
So interpretation, if, because while making the interpretation, definitely the honorable courts have taken into consideration the overall scheme of things. The overall scheme of things will come from the part. The part says relationship between union and state and in the legislative field. The field of legislation. So we have to encompass our exercise, our whole efforts, only from the perspective of legislation. By law making authority or by law making exercise is not a legislative exercise unless it is under the statute. When it is a delegated legislation, CBSE is not a delegated legislation under any central act or by any state act. So, of an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the president and has received the assent, prevail in that state. Yes. This judgment, Lordship, 2021, volume 7, SCC, page 534, 535. Jigya Yadav versus CBSE. While declaring this law as a law under Article 17, the Article 13, the Honorable Supreme Court says that whatever is written there, these are enforceable in the court of law. Where is it? 118. 118. Yes. Paragraph 117 and 118. Reverting to the CBSE examination bylaws, the same are couched in the form of a code. They provide for all essential aspects relating to formal education of a students, including admission, examination, migration, transfer, curriculum, fee of various services, issuance of verified certificates, modifications in certificate, etc. These bylaws therefore bind the parties and are duly enforceable in a court of law, even by way of writ remedies, as we have seen in the present batch of writ petition. To put it differently, the bylaws of the board have the force of law and must be regarded as such for all legal purposes. It would serve no meaningful purpose. It would serve no meaningful purpose to hold this authoritative set of rules originating from the instrumentality of a state as mere contractual terms, despite there being overwhelming public interest in their applications. So CBSE is considered to be a state within the meaning of Article 12. All these things are perfectly all right. But here, Article 254(2) will not be applicable. The Allahabad High Court says 1997, so SCC online Allahabad 1082. Paragraph 6. Paragraph 6 8 and 9, Lordship, of this judgment of Allahabad. May I read it very slowly, Lordship?
Carry on.
Yes. There is nothing to show that any local government, this case the parties are Ashok Kumar Chawla versus CBSC. Allahabad High Court, a single judge, Lordship. Just for persuasive purpose, Lordship, it is not binding.
No, there's no question. We are not
Yeah.
on the aspect of binding only.
Yes.
If there's a principle laid down,
Yes.
we can very well.
Now, what status of CBSC bylaws?
Let's see it.
There is nothing to show that any local government of any part of British India proposed to the Governor General in Council the draft of any regulation for the peace and good governance. The notification dated 11th November 1929 has been annexed by the petitioner, indicates that it is only a resolution of the Government of India in the Foreign Political Department. It is not a regulation purported to have been framed under Section 71 of the Government of India Act 1919. It is a mere resolution to establish an organization to supervise and regulate high school and intermediate school of Rajputana, including Ajmer, Mewar, Central India and Gwalior. Under this act of board was constituted with the power conferred on it. Under clause 7, the board was conferred with various powers, including the power to conduct examination, admit students to its examination, recognize the institutions for the purpose of its examination, prescribe courses of instructions for recognized institution. Paragraph 8. There is nothing to show that the procedure as pointed out above were followed by placing the resolutions before the parliament. It was in the circumstances only a resolution of the Government of India to constitute an organization for exercising the power conferred on it. The board was not created under any legislative enactment. The counter affidavit has been filed on behalf of CBSC. In paragraph 3 of the counter affidavit, it has been admitted that CBSC has not been created under any statute. The version is, it is an autonomous and independent body. The expenses for running the organization of CBSC is not borne by the government. It gets no aid, grant or subsidy from the government. It is not state within the meaning of Article 12 of the Constitution of India. It was established by the Government of India in 1929 by resolution number so-and-so dated July 1st, 1929, and is now under the Ministry of Human Resources Development, Government of India. So this is the status. But now subsequently in 2021, the Supreme Court said that it is a state instrumentality under Article 12. But what I am trying to emphasize is that it is not an act of legislature. The CBSE also has, and the Allahabad High Court also has indicated, and the plain reading also indicates that it is not a legislation. The second judgment also on this point, Lordship.
Just this very territory when we are going, what would your comment be on the IPC for that matter? Whether it is an act of legislature?
IPC, Lordship. The now recent debate is on that.
Forget about that. New legislation, let it come.
Yes.
It is an act of 1860.
1860, and it is a law. It is a law.
Whether it is an act of legislature.
It is a Lordship without examining.
We are every day, we are arguing in the aspect that certain law which is brought in subsequently
Lordship
is repugnant to the provisions of.
No, some are protected under the 1935 Government of India Act.
This is 1860.
1860, like the Societies Registration Act of 1860.
Yes.
These are still, we are following
That's
those.
what we are saying.
Even that Lordship, that till 2000.
Many more statutes, Evidence Act for that matter.
Evidence Act 1907. Then Lordship, this Land Acquisition Act.
Land 1894.
1894.
So that argument is little on, we'll say unsteady kind of territory. So your broad argument is considering the scheme of chapter 11, it should be an act enacted by the parliament, then only the argument of repugnancy would arise. But Jigna Yadav, as you have fairly cited, that takes care of the thing. The Allahabad High Court judgment you are citing is probably no longer good law in view of the observations made in Jigna Yadav.
Yes. Now, for that, now, what the Supreme Court has said and the law also says that there should be conflict. Suppose,
That
let
is-
us, as
that-
for the argument's sake,
Yes,
that
that
CBSE is a legislation.
is a legislation, yes.
Let us,
Whether there is any conflict or not,
if there is any
or
conflict
whether
or
they are
not. And to
supplementing
that
each other.
aspect, the repugnancy will come.
Yes, of course.
Now, there says that they can also go and inspect. They can also have a fee structure.
So
We are
overlapping,
sailing in the same line.
overlapping is permitted, but conflict is not
Yes,
permitted.
and incidental overlapping is also permitted.
Yes, yes.
Suppose there are legislation to different field. Here the legislation is in the same field. There are a lot of laws where there is an incidental overlapping.
We'll continue at 2.
Lordship, may I continue tomorrow? I'll conclude with my whole summation.
Okay.
I 2-3 small judgments I'll place.
Mr.
and I'll sum
Borbora,
up.
Mr. Borbora, he has got very little submission to make. If you can submit your rejoinder today itself, we'll be saving time.
I can.
So at 2 o'clock, we'll hear you on what, and call Mr. Nair also.
Nair will be there.
Yes.
I'll sum up tomorrow, Lordship.
We will hear
Yes.
their arguments.
Yes.
We'll give you the time to sum up tomorrow.
Lordship.
And if you want to give any rejoinder, you'll have that opportunity.
Yes, Lordship. Highly honored.
So rejoinder.
I'll come back at 2.
Yes. Yes.
May it please your lordship. My lord, actually, I would have loved to go after completion of the entire argument by Learned Reggie. But anyway, essentially.
We'll give you further opportunity if
It's
he
all right.
says
My lord,
something extra.
Yes, I am ready now. That way, my lord, I will definitely have a last reply when he finishes. Even in piecemeal, if he proceeds towards, my lord, the disposal of the cases, it is good. And
Yes.
my lord, my first reply will be, my lord, the question of not getting the presidential assent is a question that I raised. Your lordship will definitely be called upon, both your lordships will definitely be called upon to decide upon the question of presidential assent this way or that way. That's number one. Now, we have read Article 13, Article 354 again and again. I will also read it for one last time. And before that, I submit, my lord, actually, the CBSE bylaws. CBSE is a cooperative society. And its bylaws are prevalent since the British Raj. And I will later on come to the, my lord, transition of, my lord, pre-independence laws and bylaws to post-independence era. Your lordship also raised a question with regard to Indian Penal Code. I will come to that subsequently, my lord. That will be a good area to go. It's like cooperative society. Like every cooperative society, as your lordship knows, has essentially a bylaw. In India, the Amul Cooperative Society is the largest. It is the largest cooperative society. In Assam also, there are cooperative societies. Good cooperative societies, not only these fishery cooperative societies, my lord. And every cooperative society, your lordship, there is only a limited control by the state under the relevant Cooperative Societies Act, namely the registration of the cooperative society by under the cooperative department is a must. The proceedings of the annual general meeting will have to be sent for approval. That is also a must, my lord. Registration is a must. And when the election of the cooperative society takes place, the cooperative department sends an observer. Basically, on these 3 counts, the hands of the state extend. No day-to-day regulation of state machinery on the cooperative societies. Cooperative societies are given full liberties and autonomy with regard to, my lord, as to how many shareholders they will open their shares to. 100, 200, 2,000 shareholders. That is absolutely the prerogative of the cooperative societies. What will be the salaries to be paid to the staff of the cooperative society? That is the prerogative of the cooperative society. And similarly, the conduct of the business of the cooperative society, its expansion, etc., etc. No intervention of the
Very limited intervention. I have just reminded your lordship about that. Now, coming to 254 article. One last time, I am reading it. Two 254(1). If any provision of a law made by the legislature of a state is repugnant to, it is repugnant to what? Number one, it is repugnant to
Repugnant. So you will have to, it has been argued by Learned Advocate General that there is no repugnancy.
Any provision of law made by Parliament, which Parliament is competent to enact, or it must not be repugnant, or repugnant to any provision of an existing law. This is my case. Not only the law made by the Parliament, it must not be repugnant to any other law. Now, who are the lawmakers of any other law? I'll come.
That we pointed out to the Learned Advocate General that this covers both. Not only the law made by the Parliament, but any other law, and that law is referable to Article 13.
Yes, my lord has pointed out.
That we pointed out, yes.
Two.
But his fervent argument was repugnancy. You'll have to satisfy the court on that. Two, yes. Very well.
Whether it is really inconsistent. Two, where a law made by legislature of a state with respect to one of the matters enumerated in the concurrent list, here my lord, item 25, contains any provision repugnant to the provisions of an earlier law, whether this impugned act contains provisions which are inconsistent to other law, I'll have to show. But assuming it is inconsistent and your lordship ultimately finds inconsistency, then your lordship will definitely see whether presidential assent was obtained or not.
They may be overlapping, but whether they are inconsistent or not, that is what the court is to decide.
Here, in two also, where a law made by the legislature of a state with respect to one of the matters enumerated concurrent list contains any provision repugnant to the provisions of an earlier law made by the Parliament, it is repugnant to an earlier law made by the Parliament or an existing law with respect to that matter. I am on or an existing law. Our bylaws are existing law. Then the laws were made by the legislature of such state shall, if it has been reserved in the consideration of the president, has received the assent. This is my case here, so far as 254 is concerned. Then, my lord, again coming back to Article 13, the language of the Article 13. Here, my lord. 2 and 3, my lord. We have read it again and again. The state shall not make any law which takes away or abridges the rights conferred by this part, fundamental right. To set up a school is a fundamental right. And any law made in contravention of this clause to the extent of contravention be paid. Now it says, in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India. Then it says laws in force. Again, this word, laws in force, includes laws passed or made by a legislature or other competent authority, my lord. It is not essentially lead legislations. It is other competent authority. In the territory of India, before commencement of this constitution and not previously repealed. I will come to this, my lord. The transitory period before commencement of this constitution and not previously repealed. Now that day, my lord, my friend Advocate General said the word 3A, word act is not mentioned. Thereby, perhaps, I am sure he is not going to exclude the word act altogether because he cannot. Here the word includes, it is not exhaustive. The word act may not be there. It says law includes. When it says includes, among other things, when I say include, I say it includes, among other things, this.
Yes.
Am I clear to you, lordship? And therefore, it cannot be said that a law of the state legislature an act of the state legislature is not a law. It is the law of the land. This particular, my lord, existing law definition again finds its place in another section, my lord, 266, Article 266, there is a definitional clause. Clause 10. 266, Article 266, clause 10. Here again, the
Article 266.
Article 2, Article 3, I'm sorry, 366, I'm sorry, 366.
Just.
It's part 11, my lord. It's miscellaneous part of the Constitution. It is the definitional, my lord, article.
Yes.
Clause 10 of 366. Again, existing law means any law, ordinance, order, bylaw, rule or regulation passed or made before the commencement of this Constitution by any legislator, authority, or person having power to make such law, ordinance, order, bylaw, rule. So it, in a sense, my lord, reiterates what Article 13 says, existing law, and 254.
So there is transient provisions.
Transient, even I am referring. So, my lord, it is not essentially that an existing law is always a law enacted either by the parliament or by the state legislature. The existing law can be by any other authority, or even it says any other person.
Empowered to enact such law.
Any entity, my lord, by any entity. That's how the bylaws come in. Now, Lordship rightly pointed out these bylaws, CBSEs, we are, my lord, we started way back in 1929, British Raj. So even under the British rule, there were bylaws from time to time, and even after independence. First, there were, my lord, in 1988 set of bylaws. They were improved upon, they were improved. And then ultimately 2018 bylaws, which are that other side has produced before your lordships. They improved the various chapters. And every chapter I will submit, my lord.
Mr. Borbora, if you are referring to the 2018 bylaws, you will have to satisfy the court that the Act of 2006, can you even argue that the bylaws which have been created subsequently, if there is any provision repugnant in the subsequently introduced bylaws, then the earlier prevailing state legislation, then also it will require a presidential assent.
Yes, I remember. These bylaws are very meticulous about providing the entire mechanism.
We understand, but these were brought into force in 2018.
Right.
So if you're referring to these, that means you don't say that there was anything in existence in 2006. So merely because subsequently a set of rules, assuming that they are statutory rules, comes into force, whether the state act will become repugnant or odious on account of this.
As in 2006, there were the 1988 bylaws.
You will have to refer to those only.
Yes, that's right.
You will have to refer to those only.
That's right.
Yes.
But before that, my lord, I will refer, my lord. And where the
have you pleaded, is there any pleading in the writ petition that such and such provisions of the Act of 2006, which is a fervent argument of the learned advocate general, that there is no pleading that which of the provisions of Act of 2006 are repugnant to the provisions of the bylaws as they existed?
My lord, the Act in general, the various aspects of the Act in general.
So there is no specific. His argument is that the court is called upon to consider the constitutionality of a law without there being a specific pleading, whether the court will indulge in that exercise.
I said, this is the Impugn Act. Why it is impugned? Because of reason A, B, C, D, E, F.
All right, very well. Let us see the provisions.
About my lord, the old bylaws, 1988. And
whether we have those bylaws on record.
Yes, all bylaws.
Are they on record, sir? We'll have to test the Act of 2006 on the standard of the bylaws as they existed. Subsequently created or introduced bylaws they would not subserve the purpose.
Immediately 88 bylaws are there before your lordship.
Let us see, where are they?
I think it is in the file.
Mm.
88 bylaws.
In which petition are they on record?
My lord, 2806.
2806, let's see.
দেখুন, 88 bylaws should
Let's
be
see.
there. my lord.
Hmm.
Lordship, there are various sections in these bylaws, various chapters in these bylaws, which my lord talks about,
Page number.
my lord, lordship will find here the context. Context, my lord, definitions, I will go. The number of definitions,
We are referring to page number, sir.
first page, my lord.
Are the
Affiliation,
bylaws, anyone has provided us the 88 bylaws?
yes.
No one.
My lord, there, these bylaws shall be called Central Board of Secondary
Mr.
Education.
Borbora, no one has provided us the 88 bylaws. They are not filed on the record. They are not filed a part of the pleadings.
No,
As a part of,
I said bylaws and grave leave, my lord, and then this your position, this your place before your lords. This.
you never place the bylaws. Have you done it?
I place.
कब दिया? दिया क्या? अच्छा ये वाला. Okay.
This is the oath.
No, yes. Are these the bylaws? Affiliation bylaws. These are ones?
Yes,
Okay,
88 bylaws, my lord.
let us see that.
I think those are not 88 bylaws,
Just let us check.
18 bylaws.
1988, 28 January 1988. Yes.
Yes, my lord.
Hmm.
Here, my lord, lordship will find definition and clause, all these things, affiliation committee, board, chairman, secretary, examination, first page. Then extension, affiliation, government aided, school management committee,
Hmm.
then grants in aid, head of institution, health, Indian, then Kendriya Vidyalaya, Navodaya middle class. Then it talks about no objection certificate issued by state. To that extent, my lord, it says, whenever you set up a school in Madhya Pradesh, you get a no objection certificate from the Madhya Pradesh government. Then Parents Teachers Association, private unaided school, then reserve fund. Then my lord, senior secondary school, then my lord, 26 school run by public undertaking means a school run by the public sector undertaking wholly financed by that undertaking, like our Numaligarh refinery. We are on the land provided by Numaligarh refinery land, my lord. Not like any other private land. Then, my lord, it has various sections. Chapter 2, have a lordship, page 4, my lord. Norms for affiliation. We have our own norms.
Yes.
As I said, but as on date, my lord, there are more than 20,000 schools. So, and newer schools, my lord.
Please come. You see, these very regulations
Yes,
contemplate the
I'm coming. I'm coming.
there being an act of the state government governing the issues.
Yes.
Please come to page 9. This is clause 3, I-5.
My lord, this is important, this clause. I'll come, my lord. Let me go slowly. Page 4, paragraph, chapter 2, page 4, Roman 4. Schools managed directly by public sector undertakings or by reputed societies or public sector undertakings like us, my lord, under the financial control of such public sector undertakings or by societies formed by such undertakings. Unaided, not by.
This is affiliation.
Affiliation.
This is for affiliation.
Then again, there are other sectors. Come.
Please come to 3I.
Yes, I'm coming.
3 subclause 3I. Page 9. Subclause 5, Roman 5.
Yes.
This contemplates there being an act of the state government or the state government.
That is for registration, my lord.
No.
We have said.
Salaries of staff.
Which one is the lordship is referring to?
Page 9, just above the provisional affiliation, Roman 5.
Page 9, Roman 5. There is no Roman.
The school in India.
Just my lord, just my lord. I mean, it is not telling with this one.
You are in chapter 2. Chapter 2.
Yes, my lord.
3 subclause 3I.
Chapter 2.
3 subclause 3. subclause I.
I'm sorry. it is-
Just hold on, we'll pass it on.
My,
This contemplates a legislation by the state to govern certain fields.
the school in India must pay salaries and admissible allowance to the staff not less than, this one your lordship is referring. The corresponding categories of employees in the state government schools, not less than the corresponding categories of employees in the state government schools or as per scales, etc. prescribed by the government of India, dollar or as per conditions laid down by the state government, the schools,
Conditions laid down by the state government.
that is fee,
So
fee structure.
no, not the fee structure, salary to the employees.
School in India must pay salaries and admissible allowance to the staff, not less than the corresponding categories of employees of in the state government schools or as per scales, etc. prescribed by the government of India or as per conditions laid down by the state government. The
So
schools-
it talks of legislative competence of the state government on certain fields.
This is my lord. My lord, I will have to see, my lord, because in the,
You have got some different.
yes, 88 editions, my lord, I will have to check it up overnight.
Okay.
It is absolutely not here.
Because these are the regulations which
I am,
have been placed before us.
I am having this one.
We don't know. These are the printed booklet of the
I will have to check.
board.
I think I got a photocopy. I will have to check. It's not telling, it says it is 88.
Yes,
It is
29 January 88.
88 is in my hand. It's written up to private asset.
Then
I'll have to say the fees and salaries, these two aspects, right?
not relevant with the aspect of fees and salary. Conditions laid down by the state government. So this gives a reference to the power of the state government to legislate on these points.
Two areas. It says two areas,
Yes.
two areas. Two of the
Yes.
areas I will check. There are other areas, my lord, I will check. Now, my lord, the bylaws of the CBSE, ever since my lord 1929, my lord, CBSE schools, at that time, maybe initially a handful of schools, around 100, I have reached, my lord. Then it increased to thousands. Then it increased to several thousands. They were not, my lord, running on air. The certain norms were there. Now, what, my lord, and how the transitory period took care of the, my lord, the old CBSE bylaws? That is one question I think your lordship put with regard to, my lord, IPC. IPC. Here, my lord, I will actually try to give some, my lord, reply. Now, my lord, from the date of the commencement of the constitution, what happened to the existing laws, like the various bylaws and other regulations, codes, etc., and even institutions like, my lord, three presidency high courts. The reply can be found, my lord, in our constitution. And there was a transition, my lord, period between, my lord, the Government of India Act 35 and the Indian Independence Act 1947. Now, I invite your lordships to have a look to the last article of the constitution as it is, 395, my lord, the repeal and saving section, repeal and saving provision. Because since that question cropped up,
Yes.
395 says, my lord, the Indian Independence Act 47 and the Government of India Act 35, together with all enactments amending or supplementing the latter act, but notwithstanding abolition of Privy Council Jurisdiction Act, are hereby repealed. Now, your lordship, the transitional period from a colonial country to an independent sovereign country is, my lord, always a most difficult period. And not for some existing institutions, but also for some existing laws, legislations, bylaws, and codes, etc. And even customs. And my lord, the framers were, my lord, very mindful about the transitional period for which they incorporated Article 392. Of course, my lord, and in immediate years after Constitution there, immediate years, after 1949, my lord, the Presidency, High Courts and Supreme Court, my lord, had to interpret and adjudicate upon the, my lord, pros and cons in difficulties arising out of this transitional period. I will refer to certain judicial pronouncement later on, but immediately I will invite your lordships to Article 392.
Yes.
First, it empowered, my lord, the President to remove these difficulties. President may, for the purpose of removing difficulties, particularly in relation to transition from the provisions of Government of India Act to the provisions of this Constitution, by order direct that this Constitution shall during such period as may be specified in the order have effect subject to such adaptation, whether by or any modification, addition or omission as he may deem to be necessary, expedient, provided that no such order shall be so and so, so and so, so and so. Then, my lord, 372, I'll take your lordship. Here, my lord, your lordship will have to read with this with existing law 36610, which I already referred. The miscellaneous part of the Constitution. It talks about, my lord, existing law.
Yes.
I'll not repeat that, my lord. Then 372 3. I'm because learned as he submitted that in the British Raj, it my lord, evolved through a resolution of the Government of India at that time, CBSE, and then it formulated its own bylaws. There was no act of parliament. It was a resolution of the Government of India, he said, my lord. Therefore, the transition period is very important. Here, my lord, 372, continuance in force of existing laws and their adaptation. Notwithstanding the repeal by this Constitution of the enactments referred to in Article 395, that is repeal, my lord, but subject to other provisions of Constitution, all the laws in force in the territory of India immediately before commencement shall continue in force therein until altered or repealed or amended by a competent legislature of or other competent authority.
Yes.
The erstwhile CBSE bylaws have never been repealed, my lord. They continued and they improved upon gradually by one edition and then another edition of the bylaws, my lord.
Yes.
About your lordship's query, I'll check up tonight, my lord. My copy is not telling, my lord. I saw rightly lordship pointed out 2 areas, even staff to the salaries and these 2 areas. But there are many other areas. I'll come back tomorrow. Then here it said, my lord, 2, for the purpose of bringing the provisions of any law in force in the territory of India into accord with provisions of Constitution, President may by order make such adaptations or modifications of such law, whether by way of repeal or amendment, as may be necessary or expedient, and provide that the law shall, as and such date may be specified in the order, have effect, subject to the adaptations and modifications so made, and such adaptation or modification shall not be questioned in any court of law. Done. 3, it is important. Nothing in clause 2 shall be deemed to empower the president or make any adaptation or modification of any law after the expiration of 3 years from the commencement of these constitutions. No, now, my lord, these bylaws, even after 3 years of the commencement of this constitution, bylaws were never, CBSE bylaws were not repealed. B, to prevent any competent legislature or other competent authority, here again the word is important, other competent authority, from repealing or amending any law adapted and modified by the president under the said clause. Here, my lord, other competent authority is the society, and it was competent to, my lord, amending any, my lord, bylaws of its own, my lord, from time to time. Explanation. The expression law in force in this article shall include a law passed or made by a legislature or other competent authority. Here again, like a society, which always frames and follows a bylaw of its own, or any competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that it or parts of it may not be in operation either or, then the other explanation are, my lord, not applicable to this case. Then, my lord, this is how, my lord, many of the pre-independence legislations continued uninterrupted.
Yes.
Of course, my lord, with some subsequent post-independence amendments, both in central and state laws. Take, for instance, my lord, the earlier criminal law that was actually amended in 1973.
74 CRPC.
So we cannot say that it is a century law. But take, for instance, the Civil Procedure Code, 1908.
1908.
In both pre and post-independence, my lord, there has been a long list of amendments, including repealing an Amendment Act of 1952 and before the 1949 amendment. My lord, I take your lordship to CPC. The page 2. Introduction, after the introduction, my lord, I will not read. It talks about history of civil procedure beginning in the year 1859 and goes on. Then, my lord, second page, list of amending acts and adaptation orders. There are a lot of amending and adaptation orders in the presidency era itself, my lord. Serial number 43 is the repealing and amending act of 1942. Then serial number 52 is repealing and amending act 1952. So this is how, my lord, even this code also remain uninterrupted during the transitional period. And it remains since the British days till today.
Yeah.
Of course, now there's a talk about Samhitas. Well, let them come. Then we may get scope to Samhita. Okay. Now coming to state legislations. These are all central codes. IPCC, IPCC.
Samhita is already in existence. It's just a translation of the name. CRPC is Dan Prakriya Samhita in Hindi.
I, my lord, don't know, but some 3 decades ago, my lord, I read a small English or Semese version of Manu Samhita. And that book, my lord, that raised various controversies also. That I know, my lord.
No, but Ms. Borbora, in Hindi, the translation of title Criminal Procedure Code in Hindi is Dan Prakriya Samhita. So Samhita is taken from there.
My lord, the language for that, my lord, it has been sent to the, my lord, standing committee. Interestingly, not to the standing committee of law and justice, but to the standing committee of home affairs. It's if your lordship asks me,
We are not on that. We are saying you are saying that Samhita is coming. Samhita is already in existence.
there is some write-up in Hindu the other day, and also one editorial about the name. And it discusses, my lord, official language act. And it is a major regional language, Hindi. It is not the national language. It is a major regional language. That question will come up, and that controversy is bound to come up.
Let it come. We can't anticipate.
We cannot, my lord. And this,
Vote 38 for that.
yes, pilot.
Yes.
And this is not the forum also.
Yes.
But this question will definitely come before all concerned. Name, title. Now, my lord, coming to the state legislatures during the transitional period, bearing the, my lord, Jammu and Kashmir. One of the first test cases, my lord, came before Supreme Court way back in 1957 before 5 judgments about the transitional laws, regulation, bylaws, etc., etc. And my lord, this is, my lord, 5-judge case. Go on the question of, my lord, maintainability of civil appeals as a matter of right, section 109, 110 of CPC 1908. Continued and originated from the old court.
Mr. Borbora, before we go on to the transitional part and everything, assuming that the provisions which save the transitional laws which have transitioned from pre-independence, the primary question for applicability of 254(2), which you have to answer is
repugnancy. So satisfy us on the repugnancy part first. Then we need to go into that aspect.
Yes, I'll try, my lord.
Yes.
It's not the final. I'll go next day also. Actually, I left that for clause by clause. I left that part to Nayar. And also the new act.
Because
certain amendments.
so
Now, my-
your case, CBSE regulations are there.
Yeah.
What about Mr. Nayar's cases? The state institutions,
Both the cases, in both cases, I am there.
which regulations are there for that purpose?
Which one, my lord?
For the
oh.
the institutions which are not affiliated with the CBSE,
Unaided.
state board, what are the provisions?
In that case,
SEBA.
main is it is unaided school. It is unaided school. And,
Yes.
Unaided school, you are talking about by this act so many things. That transgresses 19(1)(g), Article 19 and other. That is
19(1)(g), now the Supreme Court after TMA Pai,
And,
so many other judgments have come
and
that these fields which this act covers, they were required to be put in place
and
as per the mandate of Supreme Court.
And in that case, all right, there may be reasonable restrictions.
Yes.
That can you say that these are the reasonable restrictions? That is the main limit.
Try to satisfy the court on that.
These are very unreasonable, arbitrary, my lord, irrational restrictions you are going to put.
Okay,
That's
okay, very well.
Clause by clause. Now, also, if, my lord, I will say, during the, my lord, period of 10 years of pendency of this case, there have been certain amendments and certain, my lord, enactment of new law governing same subjects. Lordship may say this is overlapping.
Fees.
Or we may say it is inconsistent as well. We may say. So those will be the questions, and I, my lord, respectfully submit that all these amendments, since the government has the rule-making power and the amendment power, definitely, we don't deny that. The amendments. I am not saying that they couldn't have amended. They could have amended. They have the rule-making power, which includes power to amend. But your lordship, I submit that you cannot save the fundamental unconstitutionality and basic arbitrariness and capriciousness, my lord, apparent, my lord, provisions of by inserting, my lord, some amended ornamentation. That will be my argument, my lord, and cannot improve upon the overall unconstitutionality of the act. And then to say that it will be in addition to the other act. You frame another act here, make certain provisions about fee structure, maybe other things. And then you say it will be added to, and it will be in addition to the act impugned in these cases. That will not save. That will not save, my lord. And these provisions are already intrinsic in the Impunity Act. Now, my lord, what I say about the query put by your lordship, the very opening argument, my lord, the first day, I, my lord, read, my lord, clause by clause. And, my lord, the various sections, subsections, and innumerous clauses. And I, my lord, endeavored to convince this court to have a look how arbitrary and irrational they are, and how capricious they are by themselves. The question of
Is that a ground of challenge in your?
Yes, my lord.
Let's see. Let's see. That individually seen, the provisions are arbitrary, capricious, and unconstitutional. Let us see.
I have, my lord, stated.
Yes.
In certain paragraphs.
Yes, para 16.
Coming, my
Para 16 of your writ petition.
11, 10, 11, 16. Para 10 also I have said,
There are 10, let us see.
section 3(1) and section 6 of the 2006 are contradictory in as much as while section 3 is directory, that later on said my lord mandatory.
They have
The
now amended it.
may was converted to shall.
Replaced by shall.
So then here,
So probably
11.
your pleadings have made them wiser.
Yes, lordship 11.
Yes.
The petitioner states that it having complied with the regulations framed by CBSE and having been granted affiliation by the said board, further permission or recognition that too in the stage of provisional registration and final registration as contemplated by provision 6 of the act is hereby irrational, absurd, arbitrary and unreasonable. Provisions of 6 of the act and the uncanalized powers given therein to the director has the effect of defeating the very objectives, if any, even sought to be achieved by the Amendment Act of 2006, enactment of the 2006. It may be mentioned here that the preamble of the act does not disclose the objects sought to be achieved by the act. Thus, omission has led to uncanalized power being vested on the director and the impugned act being devoid of any published or gazetted objects liable to it. Then, my lord, it is about assent, paragraph 12. Then 12A, with regard to the provisions of section 19 of the act, it is stated that the same is beyond the legislative competence of the legislature and also in clear violation of decisions of the apex court, wherein it has been clearly laid down that in case of unaided private school, the state cannot take away their choice in the matters inter alia, selection of students, fixation of fees, affiliation, recognition, which have to be made available to every institution that fulfills the condition for grant of such affiliation and recognition. Statutory authorities should not be permitted to impose the terms of this scheme as a condition for grant of affiliation or recognition. This completely destroys the institution of autonomy and the very objective of establishment of institutions. In the case of unaided private schools, maximum autonomy has to be with the management and with regard to admission, including right of appointment. In the event state being unable to establish and run institutions at the same level of excellence and providence of amenities such as private schools, by curtailing the income of such private schools, it disables these schools from affording the best facilities by creating a situation of even non-profit earning based financial crunch. If this lowering of standards from excellence to a level of mediocrity is to be avoided, the state has to provide these were actually the expressions given in a number, 1 or 2 cases by the Supreme Court also. It was referred about the standard and mediocrity. We're supporting autonomy. Why autonomy is necessary? The state has to provide the difference, which therefore brings us back in a vicious cycle to the original problem, namely the lack of state funds. The solution would appear lies in the state not using their scanty resources to prop up institutions that are liable to otherwise maintain themselves out of the fee side, but in improving the facilities and infrastructure of the state-run schools and in subsidizing the fee payable by the students. It is in the interest of general public that more good quality schools are established. Autonomy and non-regulation of the school administration in the right of appointment, admission of students, and fees to be charged will ensure that more such institutions are established. At the time of filing of this application, at least my lord, the modern school case was already there, giving detailed guidelines for fee structures.
Delhi Act was under challenge and it was upheld.
And some other acts my lord came subsequently.
Yes.
The filing of this case.
Mm.
One case is of 2009. Thus, in any view of the matter, attempt made by the impugned act to put shackles on the autonomy of the petitioner school in all respects is highly uncalled for, and it is in direct conflict with the observations of the Supreme Court.
You will have to satisfy us which observations, which judgment.
Definitely.
Yes.
Judgments, my lord, I will come. Then 13, provisions of section 20 of the act is clearly beyond the legislative and the state provisions are self-defeating in as much as it confers uncanalized powers on the director or his delegate to act in an arbitrary, unbridled manner for extraneous consideration. Such arbitrary and uncanalized power conferred in the director or his delegate reflects that this said act was so framed without first ascertaining the objectives sought to be achieved by the enactment in question. It is also stated that postulations in section 20 transgress upon the normal administrative functioning of the non-government schools under the grab of this. The closure of the school. Although there is another, as you say, referring to other things, that no, actually they are phase-wise giving 2 years of leeway to the higher secondary 11th standard and 12th standard schools, fine. What about from class 5 to 9? Where do they go? They will have to seek transfer to other similar schools. Very difficult. Other similar schools, 200 miles away. So that is one area. The power vested to the director or any delegate to enter into any school and seize computers and other equipment.
Satisfy us on that aspect,
Yeah,
that is, this is not permissible.
So, my lord,
Prima facie, we were also of the view,
then
there is
also I
power
thought-
of seizure and power of taking police aid
yes,
seems to be little unreasonable.
yeah.
It satisfy us that why this is unconstitutional.
So about my lord, the challenges, more or less, my lord, we have in our pleading set.
Okay, very well.
So it is not that out of the blue, we are reading the various sections and then challenging them, my lord.
Okay.
And the virus constitutionally, various sections and innumerable sections and clauses, my lord, are writ large on their face. I'll try to argue, my lord, actually tomorrow, Mr. Naya and also myself, my lord, I will distinguish some of the cases which I already relied on, and I will place my decisions also tomorrow.
Definitely.
Further there, my lord, I will say the virus constitutionally is apparent on the face of my lord, various sections, subsections and innumerable clauses. 1, 2, 3, 4, I will again read. And they are so arbitrary, irrational, unconstitutional, unguided, my lord, that the doctrine of severability will come in here. That will be my last argument.
Okay.
Doctrine of severability.
Yes.
What I submit, my lord, endeavor to submit, is that the various sections and subsections are inextricably and inseparably interspersed.
Yes.
Around 30 sections. 30 sections and 120 subsections and clauses. They are inextricably and inseparably interspersed that some portions of the act cannot be self-sustaining and capable of being separate, capable of having separate enforcement with regard to the bad provisions liable to be stricken out.
Yes.
Notwithstanding the amendment made during the last 8 to 10 years, during the pendency of the case, and enactment of another new act governing the fees and other things, my lord, this Impugn Act of 2006, my lord, if it is said that now these provisions are good enough for sustained and to be sustained, and they are capable of their individual enforcement, my lord, we may be mistaken that other bad provisions are liable to be struck out, and that therefore the doctrine of severability or the corollary to it, inseverability may come. The entire act is, my lord, liable to be struck down, and rules thereunder, as I said, will go automatically, my lord.
Okay.
Now, without, my lord, immediately repeating, my lord, I will repeat. I summarize, my lord. I just try to summarize the irrationality and arbitrary unconstitutional provisions in a nutshell, my lord, today. How unbridled they are. This act, my lord, extends to the territories of territorial jurisdiction of Assam. CBSE's academic and managemental jurisdiction is all over India and even abroad. In 1960, there were 300 odd schools. In 1928, 2,300 schools in India and 2020 in foreign lands. out of which, my lord, around 1120 are Kendriya Vidyalayas, 592 Jawahar Navodaya Vidyalayas, and dozens are, my lord, DPS schools like me. Some affiliation, of course, no objection from states before opening any CBSE school is provided by the CBSE's own bylaws. Our bylaw said that you have to take no objection while setting up. So the same thing has been now provided, and it is bifurcated, that provisional and then final. Initially provisional, then wait, and then final. This is, my lord, absolutely, my lord, in contradiction to our provisions of the bylaws. Although we are funded, my lord, land given, resource given by NRL, state PSU, we are definitely aided by, my lord, the central government or central public sector company. And the state, my lord, now wants to close down these schools on any given day, both in respect of existing schools or newly set up schools. On certain accounts, they may not be satisfied with the newly set up schools. And yet, in some cases, they may be dissatisfied with schools, my lords, which are running for last 30, 40 years, like our schools, my lord. We were running since, my lord, 1997, this NRL DPS. And about phase-wise clear, I said, this provision is also arbitrary.
Tell us, sir, in this, when we are looking at affiliation bylaws,
Yes.
the bylaw number 2 subclause 20. You have it, sir?
I am finding
1988 bylaws, 2 subclause 20. Mr. Mazumdar, you are having it? No,
I don't have the
CBSE bylaws.
the 2018 I had, trying to trace it out.
2018, yes. Sir.
Trying to trace it out on the net, for some copy of it.
the new one, looking for protest question like what is subclause. I think the new one is here. 2018.
The one I have was last amended on 2007. I got the 2007 amended of 1980. The original 88 amended.
In the 18 provisions, Mr. Barbara, in the 18 provisions, have a look at 1.3.24 and 1.3.25.
Yes. Recognition.
Education Act of the concerned state. So if there is no act, how would there be a recognition?
There are two
This
things.
talks of certain acts to be done by the state government.
Yes.
And under statutes.
Yes.
So if the statute is declared to be ultra virus, how would the recognition come around?
My lord, the right to education came in 2009.
Forget about right to education.
Right.
Education Act of the concerned state. Then 1.25. NOC means a letter issued by the education department of so and so for affiliation. Now, if there is no statute governing this grant of NOC, can it be conceived that a school which is to be established or which seeks affiliation with the CBSE straight off goes to the Secretary of Education? All right, give me the NOC. Is there required to be a structured statute legislation wherein these acts can be done?
In our bylaws, I'll have to find out.
Okay.
In our
Very well.
bylaws, and there are two things. Registration is different and recognition is different.
Yes, yes.
We'll have to see that also.
All right. You address us on that because your affiliation bylaws contemplate there being in existence an act of the state. Now, what would be the field of that act? Whether the act which is framed is in accordance with the provisions of the constitution or not? Or what provisions are arbitrary or offending the provisions of 19(1)(g? That you will have to argue.
And my lord, I think we will have to also consider the unconstitutionality and my lord contradiction as existed at the time of my lord enactment of the act and gather notice.
No, they have improved with time.
The
The amendment of 2018 are not challenged.
no, obviously not changed. Obviously not changed. Then my lord, coming to this.
Yes.
And also equality demands my lord application of the act to all private schools, small or big. Then my lord, what is the implication of school being made to obtain administrative recognition? Here again is the word administrative recognition. Then my lord, registration is different, recognition is different. They are using some haywire terminology. It provides for prior permission and administrative recognition, my lord, section 9. We'll have to see what do you mean by prior permission. Prior permission is before setup. On existing schools, what administrative recognition is necessary? About requirement of such recognition too big as land, I'll not go into it. No action.
Same provisions are there in your bylaws.
So, and they say that unaided schools, we shall not run for profit.
That is what the Supreme Court says time and again now.
Sustenance is also.
It's only sustainability, that's all.
And my lord, one thing.
No profiteering.
And my lord, one thing about staff salaries and private, they have not given any facts and figures that this school of DPS Numaligarh, this is how they are paying poorly to their teachers.
We are not on statistics, sir.
Here, my lord, I would like to draw your lordship attention to one thing. BSc, government has failed to provide government jobs to the thousands and lakhs of BSc and MScs. They have not got jobs in a provincialized higher secondary schools. So they had to look for jobs and therefore they had come to these private schools by their own volition. We have not.
That is right, sir, that is right. But you have been given that freedom to fix a free structure which can sustain the institution as well as the staff without you being able to garner any profits for the purpose of commercialization.
These cases,
so charge the fees accordingly.
They are not uttering the word profit. They are uttering at times the word surplus.
So that's what we are saying, that you have been given that freedom.
Yes.
So charge that fees which can sustain you for paying the salary according to the regulations prevailing.
And
a decent salary. They don't define. They pay them at par with the state government employees.
This is the time scale.
Yes.
This is the increments. They have not.
They have not said so. So at least you are safe that way. You can continue to exploit good quality faculty member by paying him 20,000 a month. That is what the schools are doing. Teachers are paid less than grade 4 employees in the state government. It's a fact.
My lord, employment. Can they control the corporate houses of Reliance and Airtel, where the MSc students are serving, that this should be the minimum salary? In a way.
That is a profit-bearing enterprise. But you are not.
They will have to fit.
You are offering a charitable service, education.
There we are more handicapped, actually, if we go by that, and yet expand our.
You have chosen to set up an establishment for the purpose of pious purpose of imparting education.
Now they are talking about 2 acres of land. In our school, what we have? A football ground, a basketball ground, a swimming pool.
So that's good, appreciable. That is a minimum basic requirement. Mr. Borbora, put yourself in the steps of a parent who doesn't have means to send his child to Numaligarh. Okay. He wants to send him to a village school. Now, if that village school is running in a small shed, would you be happy with the situation? Those are the situations these acts want to prevent. We had that spate of law schools running in garages. What kind of lawyers came out of that? You have seen that. So that regulation is required. Bar Council did not exercise its powers properly. That is why those institutions came up. We have had batches of those students. Though that generation coming out of garages, colleges run in garages.
Quality is something, my lord, which cannot be codified, I respect. Quality and my lord.
All right, sir, but the basic infrastructure, the basic requirements, library,
Yes.
they at least some kind of recreational facilities to the children. You just put the children into a hall of 40 by 40, divide them into 3 classes, 5 classes. Whether it will be good for their health. So these regulations have to be in place. Anyone wants to set up, he knows very well that these are the standards which I'll have to maintain. Without that, I'll not be permitted. Chapter closed.
So that is how the government.
You are stepping into this occupation with your open eyes, as you are saying that the employee comes with the open eyes. When you start thinking of setting up the institution, you are coming out with an open eye. If there is any deviation, you are given time to rectify. Why the provisions are unconstitutional? Look at it from the side of the parents, the children.
No, that's right. To what extent, my lord, they can.
Yes, to what extent we understand. You see, few of the provisions may be severable, which to our mind also, seizure. A police officer can't enter a building without a warrant, and the director can enter and make a seizure. Take aid of the school. Without any notice, he brings the entire police station in the school. The reputation of the school is gone. Unless there is a suspicion of an offense being committed, why the police enters a building, a private building for that matter? That is what they will have to answer.
So, Lordship, then, my lord, the parallel managing committee, my lord. We already have a managing committee in place.
They make it compliant to their requirements. That's all. There'll not be 2 managing committees. There will be only 1.
That's what they are making. My lord. They are making a managing committee as prescribed by them.
But the prescription is same. The members are same. The composition is same. Just check. Is there any difference?
My lord, there will be interference, managing committee, because the managing committee.
No, they can't be.
We will have to place my audits and accounts and all these things, and they have.
Yes, so that is to find out whether you are indulging in capitation.
Yes.
That is the reason.
Yes. We have been in place.
You see, this is an area which the CBSE regulations doesn't cover.
No, our bylaws it is mentioned, my lord, what are the nature and function of the.
Your bylaws, we are not bothered, sir. We are bothered about CBSE regulations or the CBSE guidelines.
No,
so in that, there is no system of checking the counts of the schools.
No, your lordship will also see if there is already a well-oiled machinery and various provisions governing various these aspects of the school, and how this transgression is welcome. Definitely, that is one question, your lordship.
Very well, we'll see that.
If we have already some well-oiled machinery in place, my lord, functioning for my lord, 8 decades, 9 decades, my lord. Why suddenly this should come, my lord, and replaced by some other propositions and other infrastructure, other proposition and other mechanism evolved by the state government. That also.
Mr. Borbara, one question you will have to answer. You are one school who has come forward to challenge this regulation. As you said, there are how many thousand schools now?
Now 22,000.
22,000.
Yes.
None of them have challenged.
In India. Because
in Assam, how many are there?
No. 20,000.
How many are there in Assam?
My lord, in
a rough estimate.
No state. Such type of a my lord legislation has been.
No. You're mistaken. Now these regulations are there everywhere. Rajasthan has those.
Not my lord, the ditto regulation. My lord, he has said about Rajasthan regulation. Is it the same, my lord? He has not shown. He has shown about one case, my lord.
You bring out that, download that act. Download that. You will find it.
And what about the other states, my lord? No.
There is no, you will have to show that the other states have it or not.
No. I will have to show, my lord, how I am endangered by this act, my lord. That is my duty.
The presence, availability or absence.
It is the
availability or absence of such an act in the other states would not govern our decision.
It is they who will have to show that.
They have shown the Delhi Act, which was in existence in 1973.
Right.
So
well, this type of acts are everywhere. This is one. This is from Madhya Pradesh. This is from Gujarat. They will have to show.
We'll ask them accordingly. Yes.
Then such managing committee will, my lord, henceforth take interview, select and appoint teachers.
Yes.
And also take disciplinary actions.
So they have given you the power to take the disciplinary action.
No, they
you just can't
No, they have incorporated provisions pertaining to disciplinary proceedings against the staff. and
Principles
employees.
of natural justice, that's all they say. That's fair enough. What is wrong?
And we are to hand over a scheme of management. Why should we be? Why? We are not agreeable to. Can you compel me to give you, we have a bylaw in place. And you ask me that you hand over a scheme of
Salary
management.
structures, so that you don't exploit people.
And
Scheme
that-
of management for what purposes?
No, with regard to salary structures, conditions of service.
Yes.
Our teachers,
Fee
everything.
structures.
This scheme will be considered and then accepted or may not be accepted by the director. Means the director may disapprove. The
Yeah, so
entire
they-
bylaw, entire
You, then you
bylaw.
have got a right of appeal now. About that, we had some issues regarding the director having been given absolute powers without any control.
The parents.
Now they appellate
Under the provision, the parents have the right of appeal, my lord, not the school.
18.
Right?
Let us see, under the new amendment.
Yes, I am a school.
Just let us see.
Appeal provision is 28.
28, where is new one? No?
In the book.
It's at page 349. no?
592.
590. Okay, appeal is for, not for the school. Just let us check. No, everybody. Any non-government education institution or any individual. Where are you arguing?
For parents, fee structure appeal, other appeal
Any order of the director.
of the director. About fee structure, one appeal provision was there. There the parents can go.
No, it's an order. Any order of the director. Yes.
And my lord, it says, apart from seizure, they prescribe the procedure of disciplinary state, section 15, my lord, they state will prescribe procedure in disciplinary proceeding matters. Section 15. Under section 14, we are.
No, state will prescribe means what? Where are you reading from?
My lord, section 15.
15. School appointment authority shall issue appointment letter.
Appointment and disciplinary school authority shall issue appointment letter in the event of any appointment. No employee, government educational institution shall be dismissed, removed, reduced in rank, provided without giving him the reasonable opportunity and without matter being referred to the managing committee for its provided school authority may suspend an employee. Procedure to be followed disciplinary matter. Procedure to be followed in disciplinary matters shall be such as may be prescribed. Subsection 3. They will prescribe. The director will prescribe. We have a system in place, my lord. And again, code of conduct also they will prescribe 16. Every employee of the non-government educational institution shall be governed by such code of conduct.
All right, code of conduct just.
We have
government.
We have it.
What is wrong? The government prescribes a code for its citizens. Indian Penal Code is a code that you will not act in derogation of these provisions or else you will be in offense.
No, my lord, I will submit. If you provide this one and then again this one, you virtually take over. You virtually take
these
over.
are guidelines.
Our system in place will become redundant.
You transition.
We have to go by only what we decide.
This is a transition. So transition to a better system. What is wrong?
How can I say it is better?
That is what the government says.
No.
And that is why the constitution gives power to the government to legislate.
No, we will be in the grasp of a more draconian, my lord.
All right, satisfy us, we'll see. So, okay, next.
More draconian, my lord, arrangement, my lord, it may be.
Yes. You see, in case of labor, Ms. Barbara, in case of labor, Industrial Disputes Act is there. So, is the employer given a free hand in the manner of firing of a labor? No.
Yes.
So they are also private entities, private organizations, establishments. So they are governed by a set of rules. So you are also governed by a set of rules that today you call a person, employ him, a contract is signed that you will have a bond of 3 years. And then one fine morning, after 3 months, you chuck him off. That is not permissible. That is exploitation. So in order to prevent you from doing that.
My lord, power of termination by giving a check in lieu of my lord notice for 3 months. It is in every my lord. Take the Food Corporation of India Act. take the other central act, the power of termination is all around there, my lord, in various central governments. Agencies, my lord.
Satisfy us from any Supreme Court judgment that this power of disciplinary authority,
My lord,
it can't be taken away.
Those cases I will come.
Yes.
Immediately I was saying about the, my lord, severability. Severability, I wanted to put some decision.
Yes.
Severability, my lord, I submit that all these, my lord, sections and subsections, supposing the lordship finds that no, some of the sections or subsections are all right, but not all right subsections and sections and clauses are so many that they are inextricably inseparable. It is my humble submission on my lord severability rather non-severability. My lord, here, my lord, I want to point out to your lordship one thing. One decision.
Yes.
The right from my lord, I will not all cite many of these cases, right from A.K. Gopalan to my lord Minerva Mills. This question of my lord doctrine of severability has cropped up. And there are some basic, my lord, principles on the basis of which, my lord, the Supreme Court has said in cases at times upheld the act, and said that no, they are severable. At times said no, they are inseverable. But the principles I am trying to place before your lordship, all such, my lord, verdicts followed the, my lord, the British and American principles, my lord, of severability. I will, my lord, refer to, my lord, one decision, old decision, my lord, 1957 Supreme Court 628. I gave a book list. I have the book already. This is, my lord, Crawford and College Statutory construction, followed in, my lord, a lot of cases. There are 57 Supreme Court, my lord. 6 to 8, no? No. Right. Yes, my lord, I'll straightway go to 636. Page 636, paragraph 11.
Yes.
Paragraph 21.
21. Yes.
The all 5 judge ratio, my lord, old is gold at times. It talks about the Bidi Manufacturing Act, my lord. Immediately after independence. In 50, the question related to constitutionality of section 4. Central provinces and bearer regulation manufacturers of Bidi, agricultural purpose, 1948, which provided that no person residing in a village specified in such order shall during the agricultural season engage himself in the manufacture of Bidi, and no manufacturer shall during the said season employ any person for manufacture of Bidi. This code held that the restrictions imposed by section 4 were in excess of what was requisite for exceeding the purpose of the act, which was to provide measures for the supply of adequate labor for agricultural purpose in Bidi manufacturing areas. That purpose would have been achieved by limiting the restrictions to agricultural labor and to define hours, and that as stood, the impugned provision could not be upheld as a reasonable restriction, which Article 19(1)(g) dealing next. This again, my lord, observations will come in our case also. 19 whether these restrictions were, my lord, required could have been achieved by limiting the restriction. By this impugned also, you could have attained your object by limiting your restriction, not so many restrictions. Why 28 restrictions? It could have been done by 4 restrictions. Then, my lord, the law, even to the extent that it could be said to authorize the imposition or restriction in this regard to agricultural labor cannot be held valid, because the language employed is wide enough to cover restrictions both within and without the limits of constitutionality, permissible legislative action affecting the right. Then, my lord, now it should be noted that the impugned provision section 4(2) is by its very nature inseverable and it could not be enforced without rewriting it. The observation aforesaid must be read in the context of the particular provision which was under consideration. This really is nothing more than a decision on the severability of the particular provision which was impugned therein, and it is open to the same comment as decision in 1950. When the statute is in part void, it will be enforced as regards the rest. If that is severable from what it is invalid. It is one part. It is immaterial for the purpose of this rule whether the invalidity of the statute arises by reason of its subject matter being outside the competence of the legislature or by reason of its provision contravening constitutional prohibition. Paragraph 22. That being the position in law, it is now necessary to consider whether the impugned provisions are severable. In their application to the competitions of a gambling character, assuming, of course, that the definition of prize competition to the other, it was a minor prize act,
Yes.
is wide enough to include also competitions involving skill to substantial degree distinction. It will be useful for the determination of this question to refer to certain rules of construction laid down by the American courts, where the question of severability has been the subject of consideration in numerous authorities. They may be summarized as follows. These are the principles, my lord. In determining whether the valid parts of a statute are separable from the invalid parts thereof, it is the intention of the legislature that is the determining factor. The test to be applied is whether the legislature would have enacted the valid part if it had known that rest of the statute was invalid. 2. If the valid and invalid provisions are so inextricably mixed up that they cannot be separated from one another, then the invalidity of a portion must result in the invalidity of the act in its entirety. On the other hand, if they are so distinct and separate that after striking out what is invalid, what remains is in itself a complete code independent of the rest, then it will be affirmed notwithstanding that the rest has become unenforceable. 3. Even when the provisions which are valid are distinct and separate from those which are invalid, if they all form part of a single scheme which is intended to be operative as a whole, then also the invalidity of the part will result in the failure of the whole. Here. Likewise, when the valid and invalid parts of a statute are independent and do not form part of a scheme, but what is left after omitting the valid portion is so thin and truncated as to be in substance different from what it was when it emerged out of the legislation, then also it will be rejected in its entirety. 5. The separability of the valid invalid provisions of a statute doesn't depend on whether the law is enacted in the same section or different section. It is not the form, but the substance of the matter that is material, and that it has to be ascertained on an examination of the act as a whole and of the setting of the relevant provision. 6. If after the invalid portions is expunged from the statute, what remains cannot be enforced without making alterations, modifications therein, then the whole of it must be struck down. They tried to make certain amendments and abjure it, my lord, during pendency of our case. And modification therein, then the whole or it must be struck down as void, as otherwise it will amount to judicial legislation. In determining the legislative intent on the question of separability, it will be legitimate to take into account the history of the legislation, objects, title. When you take the history of your legislation, then you will have to take the history of the CBSE bylaws also and their enforceability in India. And title and preamble. It may be in my case, it is the state, my lord, insisting on everything. Here, my lord, I leave it to Mr. Nair, to my lord. I'll come back to this definition. You take your logic clause by clause. So my ultimately doctrine of severability. If so many sections are bad, it will be misapprehension. And
Nothing can be salvaged.
if at all we
Entire
succeed,
act will go.
if we succeed
Yes.
to establish that yes, they are inconsistent, and in so many sections and subsections and clauses, That you cannot separate and keep intact one part and
Okay, okay, very good.
I think I am clear, my lord. Now I leave it to my junior.
My lord, should I continue tomorrow or like completes and then I can comment?
Okay, very well.
My only thing, my lord, would be, I'll try to show before my lord, why this act was done. Just an outbreak, my lord. This act was done so that, my lord, profiteering, excessive fees, my lord, salary, all those things can be controlled by the state. Now, while doing.
Control
Or observed or monitored by. the state.
monitored, yes.
Now, these all things have come within the Fee Regulation Act. Everything, and it's a complete code in itself. If that is a complete code in itself, then, my lord, the concept of implied repeal will come, my lord. Now, the question is, what would be the effect of this Act, 2006 Act on the Secondary Education Act and the, my lord, Assam Secondary Education Council Act? The subsequent Act, 2018, it refers back to the Secondary Education Act. It does not refer to this Act, my lord. It refers to the Secondary Education Act. And if the Secondary Education Act is holding the field, my lord, I am an existing school. I fulfill the condition under the regulations and of the Secondary Education Act. Now, my lord, you are requiring me to fulfill the regulation.
All right. If you are an existing school, different thing.
I'm an
What about a newly a school which is now to be established? New establishment.
My lord, this can be controlled by the state government through these two bodies, my lord.
Satisfy us then.
I'll do
All
that.
right. Tomorrow.
Lordship.
Hearing continues. List. Arguments remain inconclusive. List for further hearing tomorrow.
Much obliged. Lordship.
Anything
Supplement, yes. Supplementary list, item 29.
Lordship, in this matter, Lordship, we are paying for 2 days time, Lordship, to get a proper instruction from my clients, Lordship.
What is the matter about?
Lordship, that's a APSC matter, Lordship, the district manager.
Lordship has heard
whether-
the matter in land. Lordship has seen the mark sheet manipulated.
Cutting,
There was some
manipulation.
corrections
Lordship is to
were
pass on.
List on
The
Wednesday.
Lordship has
lagadi.
heard it like
Wednesday. Yes.
It will come up on Monday one.
Wednesday.
With this witness.
You want us to list it on Monday?
Can it be on Thursday, your Lordship? Can it be on Thursday? If it is not inconvenient, Lordship.
Let it be on Wednesday, 30th.
Lordship.
ये लगाना है।
Please, please study.
इसमें साथ लगा दें।